It's on motion. Motion.
For an upgradation, I'm praying my lord one matter for
Please mention the urgency, hand over the slip.
May I also mention a matter for inclusion? It's a new writ petition matter at the motion stage.
Hand over the slip.
Lordship, for inclusion of motion.
May I mention one matter? It's a review application, Lordship, order.
A new motion, my lord, appearing in the monthly list 154, my lord.
You want upgradation?
Yes, my lord.
Please mention the urgency, hand over the slip.
Yes, my lord, I shall do that. Yes.
I'm led by.
Get this come next week.
Please indicate the urgency in the. Have you indicated the urgency?
The Land Reforms Department gave us permission to
Please indicate the urgency. Yes, call the list.
Number 126.
In item number 1 from 1 to 6, my lord, I mentioned this.
Yes, yes.
My lord, one submission, my lord, may I make?
Yes.
With a great expectation and hope I have come before the lordship, so that your lordship kindly hear my matters. Only one point.
Yes.
Whether under the Minor and Mineral Regulation and Development Act 1957,
Yes.
whether the state government makes the rule contrary to Central Act, and the year or period of excavation of sand has been lowered down,
Yes.
and thereby they say your term has expired. Secondly, my lord, in the meantime, from my sand blog, I have taken the photographs and all these things. Every day I have made him a personally party, Abhishek Mondor, a particular goon of having blessing of a district headman. He is doing everything. He is carrying out all this excavation, abruptly. I have been deprived. If you lordship kindly hear me for 20 minutes, not more than 20 minutes, I'll argue before your lordship.
Yes.
Lordship, I appear on behalf of the corporation. The lease was granted in favor of the petitioner in terms of 2016 rule. Lease has expired in 2002. After expiry of the lease, 2022.
Yes.
I know I was given in 1999, 2019.
Yes, it expired
in 6 matters, in 2002, 22,
At
2023.
that point of time, he was not born. It cannot be given retrospective effect. That is the point.
Yes.
Now, the law says the expired lease cannot be extended. Even after expiry of the lease, it came to the knowledge of the petitioner that due to resistance of some local people, he could not enjoy the entire lease period. There was no administrative latches on the or based upon which the petitioner suffered any loss, if at all, and it is settled law as on date. The Honorable Division Bench has held that it's a commercial contract. If the lessee has any grievance, it is for the damage before the appropriate court. Now, even during the existence of the lease period, it was not communicated to the authority that I have been prevented by some local people who are not allowing me.
I have communicated. Why is making a wrong statement? I have communicated thrice or 4 times. Why is making a wrong statement?
He prayed for extension.
Yes. Did you consider that prayer?
So that will be considered by the ADM, not by.
Still pending.
Hey, Rampa. Dispose of which representation?
Wrong statement. I cannot say anything.
Lordship, I mean,
We have made
submitting
Take
from
a
the pleading.
decision on that.
Lordship, the ADM will take a decision.
Decision has to be taken. If he has made a prayer, if you have taken a decision, that can be considered. If you have not taken a decision, you have to take a decision on that.
Only for 10 minutes or 20 minutes, you will I will finish. You will also know the I will take on 20 minutes. Let them say what
Is a prayer.
Mr. Vadajaji, have you made any representation? Where is that?
there and everything like three people. And he gave me time,
All right.
particular day.
No, discover পড়েনি।
One, each matter is to one point. That is try to develop it. And you know, write down this.
কত নম্বর আছে লিস্টে থাকে ফার্স্ট ম্যাটারটা কত নম্বর দিই
Heard Mr. Bhattacharya, the learned senior
5179.
advocate for the petitioner
5179
and the learned advocate for the corporation. First up, anyone appearing for the state?
Mr. Guchaitis in one matter.
Item number two,
Their appearances.
ওই
And the
আমি
learned
যেই
and the learned advocate for the respondents corporation. First up, list this matter under the heading motion
within his period actual representation annex
on January 29, 2026. Yes, call the next matter. 1 to 6, same order.
yes
number seven, your lordship, I am appealing for the petitioner. Actually, my lord, the matter was mentioned, I have served notice. My lord, so that it can be fixed to lordship, so that the matter can be fixed under a hearing. My lord, pleadings are complete. So affidavit, I believe, my lord, subject to correction, my lord, affidavit in opposition and
Yes.
reply has been filed.
On the last occasion,
Yes.
both were filed.
And
This is not appearing under the heading assigned matters.
assigned matter. But
Is it appearing in the list?
no, today it is appearing.
Today it is appearing under the heading extension of interim order.
Yes.
Was it appearing in the list under the heading?
No, no. That is the reason mentioned.
Appear করছে না কেন assigned এতে?
And the interim order is still, my lord, February, it can be extended and.
End of February.
In February it is there. Then
Yes, my lord.
Then your lordship,
then why have you mentioned for extension of interim order now?
I have,
It's already there.
it has mentioned under assigned matter so that a date can be put by your lordship.
It is appearing under the heading extension of interim order. You mentioned for extension of interim order.
My lord, I stand correct, my lord. I came to know from my dealer that has been mentioned only under assigned matter, but subject to correction. My lord. Anyway, your lordship, my lord, kindly
List this matter
please,
under the heading.
after 20th, my lord, any day.
After 20th,
Yes, I may be out of.
list this matter under the heading assigned matters in the monthly list of February 2026. Yes, next.
My lord, only one indulgence I can pay, my other set. People, if you'll kindly fix any date, my lord, so that month, instead of monthly list, we both want to.
Yes, my lord, it is.
The 20th monthly list. Let it appear thereafter. Yes. Yes.
In which case, my lord, I am for the petition.
Yes. Appearing for the state.
Against the order of the day, I preferred an appeal. It is a long-term mining case.
Against the order of the,
The district magistrate, I preferred an appeal before the authority commission,
yes.
and the said appeal has been pending. Kindly take
You
the-
want expeditious disposal of the
appeal.
appeal.
And in the meantime, my lord, only on the basis, the DM passed the order.
Any
on the-
private party is there? No.
No,
Yes, anyone who appears for the state? Yes, yes, please come. You have served upon the state. Evidence service, where is the evidence service? Evidence service filed in court today is taken on record. The learned advocate appearing for the petitioner submits that the respondent authorities have been, that the respondents have been
page 38, 11 April 24, and also 13/6/2016 under Rule 36(2), that is review order.
That is the review order.
Review order.
Page.
Page 37, if your lordship, only
Page
inform,
37.
only inform.
Page 37A.
A.
Ashun. The petitioner
Service is not complete.
For the stay.
Yes,
It matter, Madam, and led by, you can declare it matter, Madam, led by Mr. Ms. First.
yes.
Service is not complete, Madam.
Service upon the,
Upon the respondents, Madam, the stage is complete with the other respondents. The petitioner himself took the bunches, Madam, and he can return. He's an old man, Madam.
But a private respondent has not been served.
Private respondent as well as.
the learned advocate appearing for the petitioner submits that the private yes. Yes, yes.
State.
Because his right leg has been some injury. Yes, developed right leg has been injured.
Here, my lord, legal high-handed act on the part of the state authority. My lord, a 10-3 proceeding was initiated.
An accommodation has been sought for, he's for the private respondent.
Private restaurant
An accommodation has another same heading. Yes, next. The state is represented, you are appearing for the state. State is represented by Islam. Every service filed in court today is taken on record. Yes, next.
Lord, I am appearing on behalf of the state respondent.
State, who is appearing for the petitioner? Why? Monday করে দিন ওটা।
And give you a
Yes, who is for the petitioner? None appears for the petitioner at the time of call. No accommodation has been sought for. Yes,
For the petition matter,
yes.
the fact is, my lord, the respondent authority started the construction of a boundary wall, encroaching the right of property of the
Respondent authorities.
without having sanction.
Which authority?
My lord, the Panchayat and the block development officer along with the
Block development officer have nowadays started constructing boundary wall.
the Panchayat authority on the instance of my lord, the military representation annexer P6, page 35, that has not been considered and disposed of. My lord,
Page 35.
representation complaint has been lost. That has not been considered and disposed of.
Yes, Mr. De, what is your instruction?
The plot of land was, my lord, told for arrear of rent against the father of the petitioner. He challenged it. The writ petition was filed as per back in 1980. Status of the writ petition has not been stated. What is the status now?
That order is
Now, no, that is interim order.
Yes,
Then, my lord, construction of boundary wall constructed by Jila Parishad, that he has stated in at page 28,
page 24.
4
In the representation.
in the representation.
Yes,
It is by Jila Parishad,
yes,
second, third paragraph.
yes.
He has applied for correction of the record of right Page 33.
His plot is 1792.
1792.
Two plots, only
So
one.
it's
section is
recorded as Kabarstan.
Cover.
That has wrongly been.
That correction has been sought for. He is saying that it has
That is
wrongly
wrongly-
been.
Correction, how can it be done here?
No, I am not praying for.
Please first correct the record of rights.
That's true. Well, that is not because the authority is concerned pending.
Yes.
My reference, something the construction has been started.
Record of right is there.
What is your right? He says it has been sold by auction.
That has been challenged. My lord, we kindly
Well,
appreciate page 32.
Maybe challenge does not mean stay. Have you obtained an order of stay?
That is on page 22.
Page 22, yes.
Next up, P3. My
Yes.
reference says, my lord,
What is
Earlier
the
occasion-
status?
earlier occasions, its application for rating allowed the order dated 7/5/9 is set aside and the rule will be restored while the petitioners putting the requisition within 1 week from date. In default, the expenditure upon the restoration of the rule status quo as on today will continue till the disposal of the rule. That has been, my lord, before this court.
Yes. What is the status quo?
My lord, that has.
What does it mean status quo?
My lord, status quo, my lord.
What is the meaning of status quo? As on that date, it means it was transferred. That status quo is
It is in connection with the auction sale.
yes.
That
Status quo. There was auction sale.
Yes.
Property was sold.
Kindly come to page
So
22.
now the property stood vested to the state. So after that, that status quo is maintained.
if it is lordship vested the state, how the records have been maintained in Kabarstan? How can it be? This is the disputed fact.
But it's not in your name.
My,
Not either in your name.
yes, yes,
So
yes. Lordship kindly see page.
what happened to this
page
writ
19,
petition?
Page 19. with
What
the
happened
order
to
of
that
the-
writ?
What happened to this writ petition? What have you stated with regard to that?
It must have.
Please show that it is pending.
My lord, that's my lord, the kindly appreciate paragraph 13 I stated. My lord,
Paragraph 13, what you have stated?
no, that is my lord, the kindly appreciate to that. In detailsly, my lord stated, my lord.
No. Is the writ petition pending? What happened to this writ petition? Because it was restored as far back as in
84.
84.
That,
So today we are in 2026. What happened to that writ
but
petition?
that information, though it is not the information that has been given, apart from that, we are in possession.
Maybe
We are
if
in
you-
possession.
maybe you are in
My lord,
possession.
it is not that.
But unless you can show, you
My
cannot unless you can show that auction sale has been set aside.
Auction sale already in status quo status position. Auction sale, my lord, they state, my lord. My respectful submission to that. My lord, I raise the objection before the constitutional authority. They are not.
Construction has been made.
That has
Boundary wall has been made.
already started construction, not completed.
Mr. Dev, what is your instruction with regard to
But just
construction?
yesterday I got the brief.
All right, you file an affidavit.
Affidavit or report. Report or affidavit, as your lordship please. Affidavit becomes
Report in the form of affidavit.
সে তো একই ব্যাপার দাঁড়াবে।
Otherwise, how can it dispose?
Very well, affidavit I will file.
The petition status quo, I'm
He
hesitant to
knows
pass.
very well what is the what.
I'm hesitant to pass an undefined order of status quo. I'm very much hesitant. Undefined order. That's very vague.
That's
Will
to
give rise to multiple proceedings.
no, so far in case
And breaking of it,
in case of
and
civil
breaking of
dispute-
it.
Yes.
So far the civil dispute, so far the authorities concern is going on. The settlement status quo as regards to be.
You also do not know who has made everything.
And you are saying you are enjoying status quo since
Look,
80.
Status quo is there. Yes. Mr. Day is right.
That's to be maintained. my
So,
lord.
so
Well,
that is there. If the writ petition is still pending, you are enjoying. No more status quo is necessary.
But I have stated in paragraph 7 also, my lord. Still
Apply
I,
for violation of that. If anything has been done in violation of that, you
my lord,
go for
that-
file a contempt.
your lordship
Yes,
knows
call the
that
next
you-
matter.
In a manner, the petitioner's land has been acquired, acquired, but no compensation has been given. That is the.
Your lordship,
That is the
this
thing.
matter can be,
Under what proceedings?
I will, thank you.
Which proceedings?
But under the old act, must be under the old act, my lord.
When? Where is the notification, declaration, particular?
We have not been given a notification.
You are saying it has been acquired.
It's been acquired because the government authorities are specifically telling that, in fact, they have created an embankment over our land in.
Are you saying acquired or utilized? Be specific. Acquired means you have the particulars. Under what proceedings it has been acquired?
Then I have to reframe it as utilized, unless it was acquired, it could
Your
not
lordship,
have been
this
utilized, but
petition may be,
Your plot.
your lordship, this writ petition may be disposed of by simply directing the respondents to deal with the representation they have given on
in a-
12th of November 2025. This may be directly disposed of within a particular time period. They will get all the information, lordship.
but,
That may be done.
In a similar manner.
That's page
which is,
62.
Item number 38, my lord has called for a report. This is a similar matter.
Report calling, your lordship, kindly gives them.
Let him file a report, a similar.
Yeah, sure.
petition, my lord,
There, you have made at least.
When this was utilized, please show me paragraph when it was utilized.
Nothing is there.
Was utilized, nothing.
That has not been specifically stated in the representation. That is there, let them come up.
In, under what project?
And
Which?
my lord, that is for preparation of an embankment.
When?
When
Embankment?
the date I have not given the representation of the. Does not.
Your lordship, may I only suggest this, because if I understand this
In the writ
irrigation
petition, have
department,
you stated anything?
no, nothing,
No, the date has
Nothing.
not been given.
So this is the original proceeding.
nothing given. He merely
It
said,
should not be so vague in an original proceedings.
The date should have been given.
may I only suggest this, because now there is a representation.
Please
place.
file a report.
No,
with
your lordship,
regard to
it will be easier for us to.
What is here?
This may be disposed of within a particular, this representation,
Bring the report.
because there are
You have
multiple authorities.
utilized,
There are multiple, so which department should be directed? It will be the secretary irrigation or? I
under
think-
what project it was
Yes.
utilized?
But this was for an embankment, my lord.
So I
have
understand the
stated.
irrigation, I understand this will be the irrigation department.
Which paragraph you have stated?
My lord, will kindly come to my representation, my lord.
Ultimately representation.
specifically states that
Paragraph 7.
Paragraph 27.
Irrigation authorities have been implemented.
Yes, they have been implemented, lordship.
Which?
Secretary irrigation, this is, I think. কাকে করেছে?
Executive engineer. Deputy executive engineer.
4, my lord, respond number 4.
Petitioner alleges
Yes, that's not a 4.
that the plots of land
Sunil Kumar Maiki put a petition asking for a part of it to as he is arguing before court.
You are there. Yes, what is this matter?
Allegation of encroachment of the national highways.
Yes. Have you implemented the National Highway Authority?
Yes, yes.
Have you served upon the National Highway? Who is appearing for the National Highway?
Monica Das. No, no. Respondent number 2 is the project director. Hmm.
Who has encroached? Private respondent.
Private
Have you
respondent.
served upon the private respondent? You are not the advocate on record. Who is the advocate on record? All right, pass over, ask him to come. Yes. Call the next matter.
May I have the state, my lord?
Similar matters, my lord, the plot numbers are different, otherwise facts are similar, my lord.
That's the same.
Same, my lord.
Plot numbers are from paragraph 2 onwards, my lord.
Same order. That's it. See. Previous item was what?
13.
13, my lord.
Same as 13. Yes, next. All the next matter.
One. Direction, or we have some calculation according to the decree.
Lord, I am not agreed with the calculation because it is of 28A. That must be covered with the certified copy of the judgment of that order and not a single farthing more than that of that order, the judge's part. And this is
Mr. Mahato, there is no dispute with regard to that. You have to consider.
yes, I have considered and I have submitted the report. I have submitted the report that what would be.
Technicals.
Yes, agree to deal into the sir. Same matter. First, kindly see what is
The first ones, the others are
Yes,
same.
yes.
Yes.
but let them say where is the wrong in our calculation.
My lord, in our calculation,
Mr. Bera, where is the judgment?
Yes.
the certified copy of the judgment.
Kindly take the judge, kindly take the repetition.
Yes, certified copy
petition,
of the
yes.
judgment.
Yes. Kindly come to page 20. Decretal
Yes.
by repetition 28 is allowed.
Yes,
Mr. Bera, where is that judgment?
judgment of that judgment.
Original judgment on the
Yes,
basis
and
of.
that is necessary. No, the well, certified copy. Certified, my lord, this is the division bench judgment that certified copy of that order is necessary.
No, this is the decree of,
Land acquisition judge.
yes.
Yes.
Oh, you have annexed it along with, no,
Degree, kindly come to the last.
now
sentence.
you have annexed along with this calculation,
Yes, I have annexed.
but you have not given that to them
No.
prior to that.
This has been determined by the LA collector himself.
Yes.
Yes.
Your lordship knows, kindly read 28A. How 20?
Please, before that, please kindly come to the decretal part.
Yes.
Yes.
The referring claimant is entitled to get compensation at the rate of 54.45.
LRA case providing similar relief to the instant be calculated.
Yes,
as
yes.
department. So unless we file the judgment and degree, the section 28A cannot be allowed.
No.
So
That is,
LRA
yes,
case of
that is-
22.
no, now please kindly come to the decretal part. Yes,
Yes.
what it has been said.
Then
Referring
that-
claimant is entitled to get compensation at the rate of rupees
Yes.
54
Yes.
45,000 per acre.
Yes.
Yes.
The referring claimant is also entitled to get interest at the rate of 9% per annum on the depreciated valuation of
Yes.
land at the rate of such and such per acre from the date of possession, that is 30th December 1988 to the date of notification,
Yes.
that is 17/4/2022.
Yes.
Sorry, 2002.
Yes.
2002.
On reduced value.
Yes, on
9%
depreciated, on
reduced-
depreciated valuation.
value. Then referring implement Solesium 54,000, Solesium at the rate of 30%.
Of the market value, that is such and such per
Yes.
acre, less than the actual payment, if any, paid to the referring claimant.
Then the
Yes.
referring claimant is also entitled to get additional compensation at the rate of 12% per market value of the acquired land from the date of notification to the date of the award from 17th of April 2022. The
Yes.
referring claimant is also entitled to get interest 9% of the entire compensation of the land value plus Solesium from additional compensation for 1 year from the date of
Yes.
notification. This I have calculated in my
My lord,
calculation. They have excluded all the items. in
no,
the
no, no,
calculation.
no, no, we have
My
not
lord,
excluded.
I
My
have
lord, kindly
Mr.
come.
Mahato, only one thing.
My lord, if your lord
Your
should
calculation
our
in terms of this judgment,
judgment.
No.
show me that.
Okay, yes.
My lord,
Show me your calculation.
Yes.
my lord, estimate is given annexure A1
How much?
Uh,
Kindly see.
In your report,
in our report.
where is your report?
2 pages,
A1.
A1.
Oh, this, not a report, not an affidavit, only report.
Only
Yes, yes.
report.
Yes.
Signed on 2nd of December 2025.
Yes, my lord.
Yes, page 2.
Yes.
Page 2.
Yes.
Top is the
Judges, my lord,
kindly see, just a minute. Name of the petitioner, judges land value, 30% Solesium, additional 20% from 2002 to
12%.
2012.
Yes,
Additional 12%.
12%.
That is from 2002 to 2022. Then they were paid by collector under this balance amount, income tax, etc.
No, this cannot be, Mr. Mahato, in terms of this judgment.
In terms of the judgment, first item 9% has been omitted.
Yes.
Then, my lord, interest has been totally omitted. Under which provision they are, my lord?
Mr. Mahato, you have to calculate as per this direction. That
Yes,
has been
yes,
done.
yes.
That has not been done.
My lord,
So many heads of items are omitted.
my lord,
You have only calculated. Please now take side by side the judgment.
my lord,
Not the decretal part.
my lord, in the earlier award, the award in what was the in the award, my lord, that those has already been included, interest, everything, award. Now, my lord, this is the, my lord, in terms of the decretal, this is the enhancement.
Yes, Mr. Mahato, you have to calculate in this manner. The compensation you have to calculate at this rate, 54 lakh, 40
Yes, yes, yes,
per acre.
yes.
Then the interest at the rate of 9% on the depreciated value
That was
of possession.
in the award that has been given. In the original award that has been given.
No, this is the depreciated valuation. In the award, that is not the depreciated valuation. Please show me the calculation in the award.
No, my lord, kindly see
Please show me the calculation in the award.
No, my lord, kindly see my calculation.
That is why
Let them see
depreciated
how
valuation
many-
of land.
What? Kindly see my
There has been
calculation.
mentioned depreciated valuation of the land. In the award, you cannot calculate depreciated valuation of land.
My lord,
But here there is no scope to file judgment degree, etc. Here it is to be
No,
calculated.
all right. Now,
But 28A is determined on the basis of the judgment passed. That must be before the collector who determine the compensation on the basis of the decision of the reference court judgment.
yes.
Now, my lord, this is the degree for the purpose so that kindly see my calculation.
my lord,
Every item I have given.
in the
They have not included so many items.
my lord, if your lordship kindly see the, my lord, the report in the third paragraph. It has been
No, report means your report.
my report.
Third paragraph, first page.
First page, third paragraph.
Yes.
has been prepared and sent for department for vetting approval, but the department sent it back with instruction to recast the same. Subsequent, the revised draft estimate has been prepared
Mr.
in-
Mahato, that is your internal thing.
in the, my lord,
May say-
that is to be calculated.
Now I have to consider whether that this is the correct
My lord,
one or
my
not.
lord,
Mr. Mahato, this
my
has
lord,
to-
it will be decided in the case of Shaharani Roy's case. So,
Shaharani Roy's case means?
man, that is the decree.
No.
19.
What is 28A? Mr. Mahato, 28A, same benefit is
May I
to be
explain?
given.
May I explain 28?
Same benefit is
Yes.
to be given.
Kindly
See,
read,
same benefit.
So
What has
this-
been given in what has been given, my lord, that is that is to be given in the 28A, not furthermore,
No further.
no further.
Yes. So this calculation has to be made in terms of this rate.
Yes.
Show me that you have made in terms of this rate. This chart does not say so. You have omitted the other items.
My lord, other item means in the award, my lord.
Show me that how you have calculated.
My
the
lord,
award.
my lord,
award of the court, not award of the collector.
কদিন লাগবে?
No, madam, let them say what item, what, madam, what
Mahato,
is the
Mr. Mahato,
mistake by
please do one
calculation?
thing.
What is the
He
mistake?
has
Let them
also
point
given
out.
a calculation because
has given calculation in the new manner.
yes.
How new
Please,
manner?
please
I have
indicate
done
where is the wrong in this.
My lord.
What is
And
the
you
wrong
have
in
to
this?
and you have to also show that you are saying that in the award this was being done.
Yes.
So if there is a revision, that this interest revision also has to be made.
In,
That you have not
intelligence
said.
means the rate in the rate it has been when it has been doubled
To show what was the calculation in the original award.
award. What was the interest? What was the interest given?
Yes.
And now, my lord, after 28A, what would be the interest?
Yes.
Yes.
And Mr. Bera has given a calculation.
My lord, he has calculated in new manner.
Wrong.
Not new manner.
He may be wrong,
Terms
but
of
you have to
degree.
show why it is wrong.
Why it is
You
wrong?
also have to give a calculation with
My
regard to this.
That's why I have given the, let us have.
Because prima facie, in this report which you have filed, in the second page, the other items have been omitted.
Other items in the award, my lord, he said the 9%
Mr.
interest.
Mahato, only one
Speaking
thing.
of award,
In the original,
the
in
Mahato
this
is
decree,
confusing everything.
in this decree was passed in the case of Ranjit Pramanik.
Yes.
Yes.
Praman.
Ranjit
Ranjit
Praman.
Pramanik.
Yes.
So in the Ranjit Pramanik, also an award was passed.
Yes,
That was challenged.
that was challenge.
So after challenging, this has been done.
What has been calculated in the Ranjit Pramanik, that will be the rate.
Please kindly come to the decretal part. Please read it slowly. Do you have the copy of the decretal part?
Yes, I have given.
Yes.
The referring claimant is entitled to get compensation at the rate of such and such per acre. So first you have to take this. Then the referring claimant is also entitled to get interest at the rate of 9% on the depreciated valuation of the land. So you have to calculate first the depreciated value of the land.
Yes.
Then
That has been done.
That has not been.
so here it does not appear from.
9% from.
All right.
this date to this
All
date
right,
is
let
not
me
there.
finish.
That is not
Finish. So
there.
on the depreciated value of the land
Acre from the date of possession.
at the rate of such and such per acre.
Yes.
Yes.
From the date of
The-
possession.
From the date of possession 1988 to 2002. Then the referring claimant is
No, to
also
the date of notification. That is.
Solatium at the rate of such
Up
and
to
such.
17th
not there.
April to
Less
2002.
than, now you come, less than the actual payment if any. So here you are excluding, only the payment will be excluded after that.
After calculation of this.
Yes,
After calculation.
your calculation is not as per as this.
But this item is not
So
included.
after that,
My lord, depreciated value rate. Yes. That is that depreciated land value is 6 lakh 8,000.
yes, so depreciated value
Where is
is,
that? Where is that is calculated here?
no,
My case.
where is the depreciated value, Mr.
That is the last.
No, the estimate, my lord, the last.
Yes, depreciated, no, this is the depreciated rate,
Like
depreciated land value, yes.
Land value.
Yes.
Depreciated land value.
Yes.
Now on this depreciated land value,
This
so
9% from this to this.
Yes.
That is not there.
then you have to add, then you have to deduct the actual amount paid.
Paid.
The
This
manner
item
of
is not
calculation is not
calculation.
right.
This
It's
amount is
not in accordance
calculated.
with this.
Then your 30% is there.
30%
which
is there.
district?
That is there.
30%,
Mr. Mahato, this is which district?
30% and 12%.
Not
Not
24 Parganas.
No.
There are very efficient officers in calculations,
What?
Mr. De.
What? But today.
I do not know whether they are now retired or not,
You was, but today, my lord, they are failing.
because
There are two or three.
I do not know whether they have,
They are very much.
I do not know whether they have retired or not, but
They have
no,
retired.
not 24 Parganas, there are very efficient officers, I am telling you.
I know my lord. I have.
This calculation
We
is
know
not
the
correct.
calculation.
My lord,
Now, these two items, my lord, this 9% from 30th December 1988 to 17th April 2002 at the rate of 46,000 dash have been
Who?
That is the.
No, he has given his calculation. No, Mr. De, Mr. Mahato, Mr. Bera has given a calculation.
Yes,
What is according to him,
I know.
according to that. Now you have to verify that, because your officers are always doing
My
these
lord, I have
calculations.
given that thing, my lord, to my officer. They please verify it.
Ask them to
As
explain
because-
it to you in terms of this
as-
degree.
As because, my lord, he's a very good calculator, only for that is my learned friend is a good calculator. So please see this and clarify this. Well, up till now,
Well,
they did
I
not
must know what is the amount, excess
Both
amount
of
I have
you are
paid
there
beyond
and
the
the
limit.
officers are not turning up.
No, my
Then
lord.
I can direct the officers to meet you if you want that.
No, my lord.
Since both of you are here,
No, my lord.
you cannot ask them to come.
Submit people, your lordship. There was some good officer, but today they are not a good officer.
ঠিক
Mr.
আছে,
Mahato, senior advocate, Lord, he is saying that the calculations should not be done in terms of this. So many items have been omitted.
No, but perhaps Mr. Mahato was mistaken. He thought that it
No,
was.
he.
Now I think he realizes.
Now, my lord,
Mr.
possibly you-
Mahato, please, both of you sit together with
Mal.
us. Since both of you are in these two matters, please ask them to.
6 matters is there, my lord. That is.
Five matters.
6.
Yes, 6 matters divided between both of you.
No, that is 6% is there. So, my lord,
No.
Both of you are there. So
Well.
ask your officers to meet you personally, not sitting in their chamber to make calculations. Ask them to explain it to you how this was made.
My lord, they are
Taking the decree, because now
Well,
Mr.
what they
Bera has given a copy of the decree. If you want, Mr. Bera, do you have a copy of the judgment?
My lord, judgment.
Please give it to them.
Yes, my lord, I have to collect it. I will give.
Please give it to, please supply it to them so that
My lord, they are in, my lord, the appeal filed by this.
Mr. Bera, I appreciate
No.
it contains that, but for
what
the
I-
purpose of
No, what I am saying, my lord, the
আমারটা
government preferred appeal.
আমারটা কি দিয়েছি?
Appeal has been dismissed. In the appeal, certain amount has been increased. Government's appeal has been dismissed, but I have not relying upon that. They can say produce, certain amount has been increased by the division bench. I am not claiming, I am claiming on, it is not that it has been reduced. Number, the Supreme Court has made it clear. But the final determination means determination up to Supreme Court. Suppose, my lord,
that
collection.
you are not claiming.
That I am not claiming. I am not claiming, and the Supreme Court judgment says if the higher court or Supreme Court reduces the amount compensation, then the claim for compensation under section 28A should be reduced.
Yes,
So that is
because
the-
that's the ultimate,
that
that's
ul-
the,
that is the ultimate degree.
Yes,
Marks is the degree. So, my lord, I cannot claim what has been finally determined. Here in this case, finally determined by appeal court, increasing some amount, I am not claiming certain statutory benefits. I am not claiming, I am strictly claiming benefits under the decree passed by the reference court. And I have
give a copy of the judgment
that
so
is
that,
in the record. I will serve.
please give it.
No,
Give a,
I will. Shall I serve everybody or only?
No.
apply any one of Mr. Mahato or
No,
Mr.
my
Dev.
lord, I will serve Mr. Mahato and Mr. De. Both of them I will.
Mr. Mahato and Mr. Dev, please exchange it with
Mal.
your other colleagues who are appearing in the other matters
My
also.
lord, I specifically directed my.
আজ পর্যন্ত আজ পর্যন্ত ক্যালকুলেশন করা কত বড় এখানে দেখো না
In spite of that, my
Because the calculation part, this is to be
up to
no, my lord, only for that reason I have.
up to 31 December 2025.
but when
আমার calculation কি?
2 weeks.
All right. 22nd,
20 seconds.
Same order, কটা আছে?
27th.
27.
All right.
They have no Gangasagar problem. They are not.
No,
They are not.
no, they do not have any Gangasagar problem, maybe, but
Both districts are.
because they have to.
So far as time is concerned, let them take time.
Mr. Bera, you have
Beyond
heard
that,
the submission. You have heard the submission of Mr. Dey.
I am not opposed to their prayer for time. Your lordship speaks according to your lordship's convenience and according to their convenience. I am going to supply the copy of the
Mr. Bera, this calculation you have given it to them earlier. This calculation.
long before vacation. I have served it on
15th.
Heard Mr.
I
Bera.
have served
No,
on
no, no, no.
15th of December.
That is not dispute. I am only asking you
Yes.
that you have served
15th
or
of
not.
December I have served.
You are filing it today. Before the court, you are filing it today.
Yes, because the matter
The-
is not hard. I have served on 15th of December.
Bera, I am only asking you. I will record that.
Yes, yes.
The you have difficulty.
But if possible, I will serve copy of the trial code also of the division
Please
bench.
supply these copies.
Both
I am
copy
not
both
passing any
copy I
formal.
will serve. The High Court's copy, High Court's judgment, and also the trial court judgment. I will
Supply all copies and please indicate which judgment you are not relying upon because you have said the enhancement you are not claiming. Please also tell it to them.
I am telling you. Both
Sorry,
copies.
no,
But that was
supply.
because 28A2 was, sorry, 28A1 was pending because the appeal was pending. After the disposal of the appeal, this petition was taken up. That has not been noted, but I will ask them the copy of that.
Yes, please serve them.
Yes.
Next.
Mr. Basu is leading a short Basu.
Today they have to produce
Item 21.
produce the two documents.
All item number 21.
Kindly see your lordship's last order.
5th January, sorry.
I am for the private respondent, my lord.
এইটা নেবেন
Almost hearing is concluded, only two documents have
Yes,
to be.
where are those documents?
Yes.
Please give a copy to them.
After they have given us the notice on 24 June.
Page 18 of this bunch.
We have submitted as many documents as we had before the KMD. On the last occasion, it was submitted.
No, show me which is the possession certificate. Show me the possession certificate.
I would come. Let me just narrate back. Initially, in respect of plot number 141, every procedure was done. Allotment letter was issued, permission was given, lease and license agreement was issued. Those are annexed over. Thereafter, certain legal difficulties came up. The petitioner's father requested the authorities to make an alternative plot allotment. Such plot allotment was done, which is the present plot in dispute. Your lordship would kindly look into page 19 here.
19 of petition or yes. Bunch.
Yes, 19.
Your lordship, here your lordship would find.
What is
that-
this document?
Your lordship, this is a document of the KMD record showing that in respect of 141, FB 25 was alternatively issued. Payment was taken. But, and it is admitted.
Which serial number? Which serial number? You are in which serial number?
Your lordship 29 here.
You are in 29. Arun Kumar Roy.
Arun Kumar.
Now,
Your lordship would see 773.
alternative plot is 25.
25.
Page 20.
Yes.
So, in respect to submission is your lordship.
No, sir. There is no dispute that an alternative land is got to be allotted to you.
Yes.
Dispute with regard to that. So show me that you have been given possession of that
Your
plot.
lordship, since then.
Allotment
the
and
petition-
possession.
Since
The
then,
Talukdar, if both of you argue at the same time, it's
since then, petitioner's father has been making repeated representations that issue was possession at. This is the admitted position that after 141, I have made entire payment. I have annexed such document where final payments are reflected. Thereafter, there was a court case which is reflected in the hearing as well. After
what is that court case?
So lordship, that I do not have instruction upon. Because of that, this
Who has filed this court case?
after all these procedures, we have come to know. The petitioner's father has come to know way back in 1997 or 1998. Thereafter, in 2008,
Now you are in possession of this plot.
this 25, every 25.
Now you
There
have
has been-
constructed.
Lordship,
Show me the sanction plan.
your lordship, I would come to that. Kindly see the lease agreement first. As KMD was.
I will
saying,
come to that. Please show me the sanction plan.
Lordship, as of now, I am not holding the sanction.
How could you construct
Your
on
lordship, kindly look
a
into-
plot of land without a sanction plan?
Lordship, kindly to page 14. I humbly submit once again that this is in respect of plot 141. But your lordship kindly looks at.
Yes.
If I may please, the third, whereas the licensee has applied to the authority for a license of the plot of land in the East Calcutta Area Development Project Phase 1 mentioned and described in the schedule hereunder written, and whereas to enable the licensee to erect a house and building thereon for use of residential purpose, the authority has agreed with the licensee to grant a license in favor of the licensee to a period and to erect a house and building thereon for use of residential purpose and on the terms and conditions hereinafter appear. This was, again, I am submitting your lordship, this was in respect of plot number 141.
Yes.
I, as a citizen, I have submitted all payments of around 13,000, 14,000 in the years 1998, 1999. Thereafter, a legal dispute comes up. I make a prayer, alternative plot is being allotted to me. I place several requests. Then I am not supposed to make further payments for SB25. It is their due diligence that they will do everything. Nothing was done. We have made several representations. Somehow, it is not possible that for 10 years, 15 years, 17 years, some person will go identify and get into the plot. There were some oral agreements. But how it was done, because the person has died, now his daughter is being troubled. Your lordship kindly looks into this from a sympathetic point of view. She has been residing there, thereafter she has given it for earning her livelihood. But all the proceedings were done in respect of 141. Today, KMD or state cannot shrug off their responsibilities that no, there was a difficulty. I have accepted payment. I have issued you everything. Now, in respect of the new plot, I will not do anything for you. And today, I'll take the.
What prevented you from approaching the court at that point of time?
Your lordship, that only the person who has expired can answer. Your lordship,
Yes,
that is a difficult situation. It is a clear and crystal case for your lordship. This has come up. This has come up when this has happened. I was not even into law. So this has come up after a long period of time, maybe after 20 years of time. But this fact remains that everything was done in respect of 141. Thereafter, in respect of 125.
We are not concerned with 141 now. We are now concerned with 25.
25.
We are now concerned with 25. Now, what are you praying for now?
Your lordship, now if 141 was everything was duly completed as was submitted by my learned friends on the last occasion, then 141 has to be given to me.
This is the
There
pertinent
will
question.
be a building on that 25. But if that 141 procedures are complete, whose responsibility was it to hand it over completely, hand it over the plot number?
So where is the notice? 24th of June 2025.
Yes, but yes, kindly similar. That is the only prayer.
That is at page 69 of your lordship's brief.
That is the only
69.
prayer. That's why.
And thereafter, I was
Immature.
requested and I have submitted the document before the KMD. Thereafter, I have made a representation as they were continuously setting and on record, I am submitting your lordship. Not on record, I am just submitting it off the record, your lordship. There has been certain indulgences that do it in this manner. Thereafter, we have made a representation to consider a case which is pending consideration. And one more thing, if I may just put into your lordship notice to see the wrongdoing. I have a very bad case as my learned friend has submitted on the last occasion. 2008, you have allotted me FB 25. How can this?
Show me the allotment later.
Lord.
Page 37.
Page 37, your lordship. And this was somewhere in 1997, 1998 has been allotted to the private respondent. There has been repeated allotments of a singular plot.
Have you implemented that party in this petition? Who is representing him?
I am representing.
And to my humble
Yes.
understanding from a perusal of the repetition that they have filed, they have been also perusing with the respective plots in 1997 or 1998, if I'm not mistaken.
1995, my lord, is the year when, my lord, this was allotted to the private respondent, the father of the private respondent.
1995.
1995.
And
The
2008,
plot is.
Talukdar, you have created all problems.
No.
You
In
have created all
1994.
these problems.
In 1994, 10 June 1994, 141 plot was allotted in their favor. In 95, that FB 25 was allotted to the private respondent. As it appears, in 2008, an alternative offer was given to this
Of the
petition.
plot which was allotted in favor of Mr.
Which was
Mitchell's
already-
client. How could you do that?
But
How
it
could you
was-
do that?
It was.
What were your officers doing, Mr. Talukdar?
No, as it appears, my lord, these 25 since been allotted to some other, and this offer was not acted up.
Which offer?
Offer of alternative plot to the
No,
petition.
no. I'm not going to that extent. I'm first asking you that this 25 was offered first to Mr. Mitchell's client. Was that offer cancelled prior to 2008? Please show me that document. How could you offer one plot to two persons at the same time? The question of their accepting the offer comes later. First, answer me, how could you allot one plot to two persons at the same time?
My lord, that document is not in this writ petitions, record of the writ petitions, and it is not with me. My lord, as it is submitted by the private respondent, because the private respondent had filed a writ petition.
You are admitting,
There they
you
claim.
are admitting that this 25 was allotted to Mr. Mitso's client in
If I
1994,
accept that,
1995,
if
I may, my
accept
lord,
that,
show that document because this is earlier, yes.
1994, 95,
5th
So-
December 95.
1994, 95, and that same plot you have allotted to him in 2008.
offer.
Yes, yes. Offer. How could you make this offer?
That was.
So, two
if-
things.
Yes.
If it is accepted, yes, you knew about that, then this offer was a malafide act on your part.
No. Here.
Show me that you have cancelled their allotment prior to 2008 when you are making that offer to the petitioner.
This was perhaps if in 1995 that
Mr. Talukdar, you have to show either allotment in favor of Mr. Mitso's client was cancelled prior to 2008 or this offer was malafide. Unless you show that that was cancelled. If that was cancelled, then he's right with regard to that plot goes, unless he has challenged.
no, this 25 in favor of the private respondent, that exact date, the allotment letter is not with me.
This is the allotment. 5th December 1995.
1990, as he submits.
Yes. So, but
I followed.
one
If
thing,
it is
Mr. Mitso, you have
allocated-
not got possession of that plot.
I have not.
Mr. Talukdar, why are you not allotting an alternative plot? Because that will solve the entire problem.
My lord, here
Look, Mr. Talukdar, you have allotted him
141.
previously 140,
141.
but you could not give him for certain reasons. Then you have given an alternative plot,
Offer.
alternative offer, which you have given another allotment or offer to Mr. Mitso's client.
That appears to be by mistake it was done.
And I was not aware of this.
Mistake,
But
then,
had it been
then he should not be penalized at this point of
No,
time if it is
now-
your
now-
mistake.
now it my lord,
And
the
what were
question
you
is-
doing, Mr. Talukdar? What were you doing from 2008 till this when this notice of cancellation till June 2025?
My lord, here the moot question arises. If we have committed a mistake in 2008 in offering FB 25, I admit, my lord, when we have already allotted in 95 in favor of some other, that should not have been offered to this petitioner. I admit that. But this offer was not acted upon.
Mr. Talukdar, how can you say who is in possession of this plot now?
Possession was neither given, never
No,
given
no, I'm
to this
asking you.
petitioner.
No, you have not given possession. I
Yes.
accept that.
So,
But I'm asking you who is in possession of plot number 25 now, as on this date?
as he is occupying that.
Since when? Since when?
My lord, this record we do not have. We have to inquire about. But they are claiming to be in possession of FB 21.
What were your
25.
officers doing? Sleeping. They do not know.
It's
One plot giving offers to two persons,
here
and some, according to you, an unauthorized person is entering upon a plot, your property, and doing something.
the
You are
problem
sleeping
is,
at your home.
it's a very small plot, 50 square foot plot.
You do not care with the smaller plots.
No. We do care. That is why we allowed.
Mr. Talukdar,
allowed.
Mr.
My
Talukdar,
lord,
there are
here-
two things.
Here the main
Mr.
question.
Mitso has also paid money with regard
Yes,
to that.
yes. Even prior to, my lord, this.
So, please take some, I'm adjourning this, please take instructions how to solve this.
Here the main question, my lord, here. If we have not allotted that 25, even if we offered, no possession was delivered in their favor. How this petitioner could occupy that plot
What
and
were you
make
doing for
construction?
this long? What were you doing for this long?
My lord,
What
it-
prevented you? So then there was collusion. There was collusion with your officers and the petitioner.
my lord, that
It has to be
perhaps
presumed
not,
then.
my lord, it is not possible for the
Has to
government
be.
to keep busy every day Whenever a complaint and any information comes to us, my lord, we inquire about it. And we inquired. And it is admitted, my lord, my learned friend could not show. He has admitted there is no sanction. There is no sanction. How could he construct on that plot? If we have done a mistake in offering that plot, which we have already allotted to someone else.
When did you cancel this allotment?
Which allotment, my lord?
At page 37.
No.
By the same letter, allotment and cancellation. On the same letter, we have been allotted another plot and cancelling the earlier one.
Earlier, no, my lord is asking
Present
about
plot.
25.
Oh,
25.
25.
Show me
we have
when
not
you have
cancelled.
cancelled.
We have not cancelled. We have allotted in favor of the private respondent, and he has moved a writ petition
No.
for seeking certain
Talukdar,
relief.
Page 37.
Yes.
Letter dated 30th of April 2008 shows that you have allotted plot number 25 in favor of this present petition.
Yes.
Show me that you have cancelled when you have cancelled this allotment.
This was since it was not acted up.
Where is the question of acting upon here? Please show me from the letter.
Lordship, since the last
Allotment has been made. You have said
Offer.
is allotted to you with the conditions, terms and conditions remaining unchanged.
Then,
So allotment made. Then allotment, there is no cancellation. Then they were asked to letter of consent for further information and necessary action on your part. That's a different thing. You have not cancelled the allotment.
coupled with payment.
No,
All payment made.
Yes, September.
payment was made in respect of 141,
Oh.
not 20.
Mr. Talukdar, now your office is allotting without any payment.
No. It's an alternative plot.
Yes.
CSC has already
So why have
paid
you
in respect of-
given an alternative plot? So without any
That-
payment, you will be giving alternative plot allotment.
Certainly not. They are in
So they have
respect
made,
of,
Mr.
in
Talukdar,
respect of
or you give
141.
them 141.
141
You
license.
give them
license
141.
deed was also executed.
Mr. Talukdar, let us forget about this alternative plot. You give them 141. He has complied with everything. Leave, license, everything was done. Give them 141.
141 was cancelled.
Could not have cancelled. You could not have cancelled. If you
That-
have cancelled,
by-
you have to give it this plot to him.
No, by that
Or you
letter
give it
itself,
141.
30th April, that letter itself, that earlier allotment was cancelled.
Yes. So, because you could not hand over that plot. So, everything, payment, everything you have received.
Yes.
So,
We are
you do
not
not say
denying
that he has not acted upon. He has acted upon because it was you to act upon, not they to act upon.
No.
Mr. Talukdar, they have complied with all formalities.
Yeah, that should be followed by delivering possession.
Your duty.
Since we have not done that exercise,
Show me that you have
So-
cancelled for not on their part not complying with certain things. Show me that later. After this, you have cancelled this allotment. Show me. When have you communicated this cancellation of allotment to them?
yes, that letter was, they are admitting that communication,
Where?
that 30th April, 141.
30th April is the allotment. After that cancellation, show me.
No, that letter itself shows. My lord, kindly have a look. at
Yes,
this.
yes.
This is to inform you that the allotment of plot number 141 in block FB of EWS 4 category offered to you BTA office memo number so and so dated 10/6/1994 has been cancelled. After cancelling 141, this offer was made.
141 cancelled.
Yes.
I'm asking you 25 cancellation. With
Twen-
regard to 25 cancellation, show me.
25 was offered to them.
Show me
But
the cancellation.
No,
Show me the
since-
cancellation.
since it was not acted upon, possession was not given to them, no formal allotment was issued in favor of this petitioner.
It's deemed cancellation. Show me the clause.
The offer was not acted upon.
What is the offer?
If he has,
Yes, what is this letter at page 38?
38 is internal communication.
Oh.
Yeah, but
38 is internal communication.
Oh, sorry. I'm on a different page. Just a minute.
That was the privilege document.
No, they have given consent. That letter shows that they have given consent as we asked for.
Then
But that should be followed by an allotment letter.
who was
were
to,
required
who was
to
to
issue?
give an allotment letter thereafter?
We did
Why
not.
did you not give that?
Since it was not given, my lord, I admitting that it was incumbent on the authority to issue an allotment letter and to also issue possession, delivery
Page
possession.
39,
Neither allotment was.
page 39.
It is internal.
Yes,
It is internal correspondence.
yes.
It
Are you
is
denying this?
No. How can we deny? This is we wanted to confirm about the right title,
Yes, what happened after this?
and this had my lord, this is regarding 25.
Yes.
What happened after this, my lord?
Page 40.
What?
They have replied this, page 40.
Kindly come to the page 40. Page 40.
Yes.
This is important. My lord, may I read this letter?
You will be hard upon fresh allotment later. I've seen that. I've marked that. I know. According to you, that was cancelled.
It's a letter dated in September 2009. What they are admitting. Lordship, kindly cease.
Mr. Talukdar,
I have not received. I'm reading from the
state. How this problem can be solved?
My lord, here one thing. My lord,
Yes.
kindly allow me to.
No, I will, Mr. Talukdar, I will go into the merits. I'm asking you, is there any way out to solve this problem?
That will have to. But
Or
but
If
here,
not, I will go on merits. I'm not saying I will not decide on merits. I will decide on merits, but prior to that, I am giving you an opportunity whether this problem can be solved.
if your lordship kindly,
Because
For-
Mr. Talukdar, please consider.
for a moment.
We will go into those legal aspects, factual aspects.
Yes.
The basic facts are you have accepted payment from two parties in respect of one plot.
No, not in respect of one plot. We have accepted money from the petitioner in respect of another plot. That is 141.
Did you return that money? Did you return that money?
We have not returned.
Why? Why have you
or-
kept that money with you?
That is
Mr. Talukdar, why have you kept that money with you? Why have you retained that money with you? Even accepting you have cancelled, what was your obligation to perform? Have you done that?
since
Mr. Talukdar, I will go to all legal points. I will hear you on merits. I'm not opening my mouth also now. I'm asking you, is there any way out to solve this problem? Because after all, Mr. Mitro also wants a plot and he has paid.
Prior to the payment made by the petitioner.
He has also
I'm
paid. So both of them
I'm not
has
blaming
made.
him.
Let us forget which plot. Let us for the moment keep aside 141.25. You have received amount from two parties for allotment of two plots.
Two plots.
So please show me that you have done your job by allotting two plots to these two parties.
May I answer for my satisfaction? I wanted to show only one page.
Mr.
As-
Talukdar, if you want to argue on merits, I will
No,
be on merits. I'm asking
no.
you,
Just,
that is
just,
why-
just to answer this.
that is why.
I followed.
So both are entitled to some plots.
I followed. I shall also
Is
try
there
to.
any way out? I am asking you. Have you taken instructions with regard to that?
Not yet. I will take instruction.
Please.
Here, one thing may I submit, since it has also fallen from your lordship, that page 39, the internal, after what happened. If your lordship sees page 40.
I will go to the internal communication, effect of internal communication, that they are
Page
prayer for
40.
fresh allotment. Mr. Talukdar, when I will decide on merits, I will go into that. I am asking you, because you being an authority, you have accepted payment from two persons for making an allotment. Admittedly, you have not, according to you, you have not allotted anything to either of them. According to you, you have not allotted any plot to either of them.
No, that 25 was allotted to.
It has been allotted to us, but physical possession is required to be handed over. The
I'm
next
saying-
steps are to be.
But FB 50.
So shall I accept your submission that it has been allotted to
Yes,
Mr.
yes.
Mitro's client?
That we.
When you have allotted, Mr. Talukdar, then it will be a different thing altogether. That is why, for the moment, I am not saying. So if you want that, I will record that and I will make observations here and now.
For that, Milord.
If you have made an allotment as far back as in 1994, 95, you could not have offered this. It was a malafide act on your part.
My lord, that I cannot.
That is
admit.
why I am asking you, please come back with instructions.
That instruction I will come.
Because both are entitled to 2 plots.
Yes.
Both are entitled to 2 plots. Please show me which 2 plots, X to A, Y to B. Please show me those.
Here, as it appears, Milord, I am not admitting that this particular plot 25 was allotted to the private respondent, and he has moved a writ petition earlier, and their direction
When
was.
did he move the writ petition?
That was Justice Chandra's order.
No. When the allotment was made, 94, 95.
From according to him, 1995.
So this is your action, Mr. Talukdar. From 94, 95, a person has to wait till 2025 for getting a plot.
No.
Yes.
They have moved since the
That is why.
original
Why they have
allotee
moved?
died.
Mr. Talukdar, why they have moved? Because you have not given them
No,
possession.
that was not the cause. In that petition, what they claim, the original allotee died.
Because of your delay.
Successors.
Because of your delay, he died.
Original allotee died. His legal heirs wanted their names to be recorded.
When the original allotee died?
In 2001.
2001.
In 2001.
From 94, 95, it takes 6 years to make an allotment after receiving all payments.
Allotment was made.
Possession, handing over possession. If you have allotted it prior to 2001, this problem would not have occurred. The more you open your mouth, Mr. Talukdar, you will be in difficulty. I am telling you.
That what is fallen.
And this is the speed in which you are acting. From 1994 to 2001, you are not allotting. Original allotee has to die. Then you ask the heirs to complete with all formalities. It takes from 2001 another 25 years to complete the entire process.
No, their allotment according
And
to.
in the meantime, you do not take care to ascertain what happened to that plot. According to you, an unauthorized person has encroached upon, he has constructed, he has mutated, and your officers are sleeping.
May I take your
But the petitioner also cannot. At the same time, I will come with instructions.
Come with the instructions. I will hear you patiently. I am telling you. But please,
they also cannot.
Mr. Talukdar, please. I think you have now appreciated the problem. So please do something before.
And their action also cannot be appreciated.
All right, I will consider all this.
How they could make construction without allotment?
Mr. Talukdar, if you want to argue on merits today, I can hear you on merits today.
Let me come with the instructions.
That is why I am saying now you are.
Now, construction is not the subject matter here. Subject matter is you have called me to produce the reports.
I shall come with this. And that is also the subject matter of construction is also.
There is no subject matter.
Mr. Talukdar, I will hear everything. There are 2 things. Mr. Talukdar, there are 2 things. Mr. Basu's construction may be illegal, that may be pulled down.
No problem.
May be pulled down. But whether the question is with regard to the allotment of the plot, that may be pulled down.
That is my
Unauthorized construction, that can be pulled down. Whatever can be done, can be done.
That appears to be
that's a different thing.
erroneously
That appears to me, and Yes, if that is so, if you admit that erroneously, then the person responsible for this erroneous act has to suffer the consequences. You have to identify that person. If you say that, with instructions, come with the particulars who were responsible for this erroneous act.
Yeah, name. Problem is name.
That you have to disclose.
And after
That you have to
process-
disclose.
after that also, after that offer, when there were no subsequent action, how could they proceed with the
Legal
construction?
points I will consider. All your legal arguments I will hear.
There
If we
certainly I
accept,
will
if we accept I am in possession, my lord, kindly consider section 27 of the Limitation Act. If he says so.
After heard Mr. No, I have not heard Mr. Basu.
No.
Heard heard Mr. Mundal.
I am accepting it, no problem.
Heard Mr. Basu Lanasi, advocate for the petitioner. Full stop. Mr. Talukdar, learned advocate, appears for the KMD authority. Full stop. After some argument, Mr. Talukdar seeks an accommodation to take further instructions from his client. Mr. Mitro
That I'm in possession.
I'm coming after.
I'm grateful, madam.
Huh?
And to Milord, I am for the petition.
Yes.
My affidavit of sanction.
Yes. Who is for the state?
I have served.
Mahato, what is happening? Take this matter with the government leader. What is happening?
Practically in one of the matter, it was listed, but I have given after the my lord has engaged Devjit Banerjee, thereafter I have got the.
Can be done. I know maybe someone is being, but nobody is appearing. What can be done? Otherwise, I have to proceed ex parte against the state in all matters.
No, my lord, we should take steps. Huh?
Yes, what is this matter?
No matter what happened, my lord, the petitioner is the owner of certain land. They had purchased the said land in the year 2022 and thereafter recorded his name, her name on the basis of purchase deed and possession. Suddenly, the respondent authority on the middle of the said land hung up a board that the land is
Which
government land.
respondent, which authority?
The block land and land defense officer.
Mr. Mahato.
Video. I have annexed the photograph that is at page 36.
Extra copy আছে?
Any other junior advocate from the state panel is here? You can take him or her as your
My lord.
junior in this matter. Please see if anyone is here.
না, না, আগে তুমি করবে।
Page 30, I have annexed the photograph. Without acquisition, without requisition, suddenly hung up a board that.
On your property?
Yes, my lord. That is shows from the record of rights, that is at page 15.
The petitioner claims to be
এটা আজকেই দেবে।
Item number 23. So Mahato, give a name
My
of your
lord.
junior. Yes.
Lordship,
Yes.
Miss Monica is appearing through virtual mode, Lordship.
My lord, I am appearing, my lord.
Yes.
My lord, I am suffering a fever, my lord. That's why I am appearing in virtual mode, my lord.
Yes. You are for the? Who is for the petitioner? Yes.
I want to withdraw this petition, my lord. There is some mistake in here.
Withdraw. The learned advocate appearing for the petitioner. Yes. Yes.
Lord, enter into a Lord exhibit or executed a lease deed, Lord, with the government for mine. And Lord, this lease deed was executed to final turns on to page 37 of the report that is executed on 9th of July 2021.
Yes. What is the dispute now?
Dispute is, Lord, after execution of this lease deed, Lord, I was handed over possession after a year of the land. Now, Lord, after being handed over the possession, I was fighting with Lord, minor brothers, Lord. Now, Lord, I made a representation. I was not given possession of the land for a period of 1 year. My period of lease deed, which is for 5 years, to be reckoned from Lord 9th of July 2021, to be extended for that period for which I was not given possession of. Now, Lord, that representation, Lord, was
Has been
disposed-
turned down.
Now, Lord, turned down, Lord, on twofold. One of the ground, Lord, I suppose is absolutely technical. They say, when the lease deed is executed, they have a portal, in which the date of registration, is entered and automatically 5 years is calculated, and in the portal, there is an record that it will be expiring on such and such. Now, this is absolutely technical, which can be corrected. Now, the second part to substantiate this, they take another point. They say, under the minor minor concession, under rule 5, it is stated that every lease deed would start from the date, of the date of registration. Now, the starting date, they say, is fixed, therefore 5 years would be fixed. Now, under the terms and conditions of the lease deed, it might as well have a selection, but this is commercial transaction between the partners. Now, in commercial transaction, if the party who is to perform the job, is not in given possession of. Now, there is a clause in here also in the lease deed, which is included in force measure, as well as if looks at the term, where I have a right to pay before them, that kindly extend the period for the delayed period, which is not at my fault. Now, be in that consideration, they do not consider that to be under that force measure, or rather they rely on preamble portion, saying that the preamble portion also states it will start from the date of registration. Now, even if I read the preamble, my submission.
Please show me the order.
Yes.
Order rejecting your claim.
But kindly take up the second volume.
Beyond the last step,
So, the first order is
প্রথম
109.
হচ্ছে ADM এর order, তারপর হচ্ছে division commissioner.
Why two orders?
ADM rejected, thereafter statutory appeal. Statutory appeal also rejected.
109.
10.
109 is the enclosure. So where is the order?
125, sir. 120. 125.
Final order is changed. 188.
This is passed by the additional district magistrate, and the
189%. Final order of appellate authority.
and the appellate authority and 189 affirming what has been stated. So 125 would be the order which
So where is this force majeure clause and other things?
So
Where is?
this were not considered. Force majeure was not considered by this. They stuck to, my lord, the issue, my lord, where the comment, from which date it should be commencing. Now, my lord, the clauses are in the lease deed.
So please show me when the possession was handed over.
Okay. Kindly turns to, my lord, page 110.
110.
That's 111. 111.
111 is the, my lord, next page, possession certificate.
Possession certificate was issued on
My lord, this is dated
22nd of
July,
June.
June 2022.
22nd of June 2022. And this lease deed was
9th
of
July.
2021.
9th of July.
That is, my lord, at page 37, my lord.
9th of July. Lease registered.
No, my lord, subject to correction, my lord. I am led by Mr. Kushal Chatterjee, my lord.
Probably, my lord, registered on 3rd August.
3rd
August, the stamp, my lord.
This is execution.
This execution.
It says from
9th
the
July.
registration.
So, my lord, 3rd August is the date of registration.
Effective.
3rd of August 2021.
Yes.
It is the date of registration.
Yes.
But I'm not going by that 10-15 days. So, my lord, I take it 9 July.
Then possession is on 22nd of June.
June 2022.
Yes. And what was the date of expiry?
Expiry 5 years from July, July 26.
July 2026.
So, my lord,
No, it is 2nd August 2026.
2nd August. 2nd August 2026. Date of expiry. Yes, where is the concession rules 2016? Yes, which clause says that it is from the date of
So,
registration?
kindly turns to rule 5 of the concession rule 2016, which they rely upon. What is what clause 5 here? The period of lease for mining operation in area shall be for development such and such, for other, B is for other minerals up to 20 years. The subsection 2 would be important here. The date of commencement of the period for which a mining lease is granted shall be the date on which a duly executed lease deed is registered as per the condition laid down by this. Similarly, it's a date of commencement.
Yes.
Now, my lord, they also rely upon in the impugn order. Sub-rule 6 of rule 10.
No, payment is how payment is to be made.
The payment by royalty, my lord, on extraction, my lord, we have to.
Yes. So it's from time to time you are extracting or you are making payment.
They are demanding, we are making payment.
Yes. Yes, which other rule was considered?
They say, you know, sub-rule 6 of rule 10.
Rule 10.6. Rule 10.6.
That was rule. There is another West Bengal minor minerals auction rule. This is not.
Oh, not concession rules.
Auction rule.
Auction rules is in this book.
Yes, but it's in.
Yes, auction rules 10.
Sub-rule 6.
The date on which a duly executed mining lease deed
The
is
languages
registered
are
shall be-
identical, so for the purpose of commencement of the lease deed,
Yes.
the effective date.
Commencement of the mining lease.
Yes. The languages are identical in both the rules.
Yes. So this was by way of auction. So 10.6 would be applicable according to you.
Yes, it is auction and minor mineral because the lease was granted in terms of Concession rules.
concession rules.
Yes. Form D is a statutory
So
format.
language is same.
Yes.
So is the stand of the authority is that this 5 years is to be calculated with effect from the date of registration. Yes, which clause of the lease deed you are trying to rely upon?
But first thing, Lord, kindly takes up the preamble.
Page.
So that page 40, internal page 4 of the lease deed.
Why you have annexed so many documents?
Look, the lease deed is this much.
Page 41 is the relevant portion.
Page 40 is the lease deed starts.
No,
No,
it's
start from
41.
page 37. I'm taking my
Preamble is
to the
from
relevant page.
Page.
Internal page 4, page 40.
Yes.
But I'm placing from the last paragraph of page 40.
Yes.
Now this indentured witness that in consideration of the rents and royalties, covenants and increments by this present and the said schedule reserved and contained and on the part of the lessee to be paid, observed and performed, the governor doth hereby grant and demise unto lessee all the mines, beds, wells, scenes of said hereinafter referred to as the schedule, referred to as mineral, situated lying and being in or under the land mentioned and described in part 1 of the said schedule, together with liberties, powers, and privileges to exercise, to enjoy in connection therewith, which are mentioned in part 2 of the said schedule, subject to restrictions and conditions as to exercise and enjoyment of such liberties, powers, and privileges, which are mentioned in part 3 of the said schedule.
So it says to hold for a
Yes.
period of 5 years from the date of
Date of
registration.
registration.
That's why I was reading slowly from the top. Except a reserving out of this demise unto the state government the liberties, powers, and privileges mentioned in part 4 of the schedule to hold the premises.
Yes. So
I mean, this is
holding.
not disjunctive. And
No, holding. Mr.
holding
Chatterjee, holding is for this period. Holding is for this period.
yes, so holding.
You have a right to hold this property for this
So
5
Milord,
years.
how do I hold this property? When I put this question to myself.
Yes.
So Milord, if to hold and Milord demise unto the lessee from. So demise unto the lessee from the date of registration. So Milord, demise and to hold. Milord, these are the two terms which gives me possession. Milord, admittedly the possession is given in June.
No, which part you are saying?
Milord, after to hold.
Yes, after to hold.
The premises hereby granted and demised unto lessee from the date of registration. So from the date of registration, I am supposed to be in possession to hold the land.
Yes.
So Milord, I am not in possession. So Milord, this is conjunctive, not disjunctive.
Yes.
So Milord, one cannot be segregated from the other.
Yes.
So Milord, if that be the scenario, Milord, then Milord, it has to be reckoned from the date of registration as well as from the date of possession.
Yes.
Now Milord, this is my first list. Milord, second Milord kindly takes up the fourth major clause. Milord, which is at page of the lease deed, Milord. Page 77, internal page 44.
Page 77.
77, internal page 44. But prior to taking to 5, Milord kindly takes up Milord the minor mineral rules first. Concession rules, Milord. Rule 21. Milord, thereafter kindly reads rule 5.
I can please place this force major rules first thereafter.
Yes. Milord, failure on the part of the lessee to fulfill any of the terms and conditions of this lease shall not give the state government any claim against the lessee or be deemed a breach of this lease insofar as such failure is considered by the state government to arise from force majeure, and even if through force majeure the fulfillment by the lessee of any of the terms and conditions of this lease be delayed, the period of such delay shall be added to the period fixed by this lease. In this clause, the expression force majeure means act of God war, insurrection, riot, civil commotion, strike, earthquake, tide, storm, tidal wave, flood, lightning, explosion, fire. Now, this is important. And other happenings which the lessee could not reasonably prevent or control. So, my lord, this adding of period is there itself contained in the lease deed, but under a clause, my lord, where the life failure cannot be attributed to me, to the lessee. And my lord, while saying so, they say for what reasons? Force measure. After force measure, explaining force measure, they say and other happenings. So, my lord, force measure and other happenings are in clause 5. So that period which is permitted to be added, my lord, is there in clause 5. So therefore, my lord, I say, my lord, even by this clause, my lord, that period which was not within my giving possession, which is admitted possession, my lord, they gave it, my lord, after the period of a year. So, my lord, it was not within my possession. So, my lord, my control. My lord, they say, my lord, I give you possession after a year. So, my lord, after this period of
What is the effect of this force major clause, Mr. Chatterjee?
well, I know where my lord is traveling to, my lord. I understand. My lord,
It is clear that
yes, my lord,
us-
if I have understood correctly, I would say, my lord would take me to, my lord, the position where I can claim, my lord, if they charge any damages, or, my lord, they say I could not fulfill the terms of query, or, my lord, could not pay, then I can be exonerated of that.
right.
Yes.
This is
Now-
your right interpretation. You are trying to
No.
give a roundabout.
No, I thought of.
Thank you.
I've
Yes.
thought of. Now, my lord, if that be so, my lord, then, my lord, there wouldn't have been a language or statement that a delayed period would be added.
For that, Mr. Chatterjee, if they are holding that you are in breach, let us suppose that there is a 5-year period. Now they have given you possession. Let us assume with effect from the date of registration. Let us take a hypothetical case, not this case. But some act of God, let us not go to those other happenings by any flood or any. Let us take the recent example of COVID-19 pandemic. So now, for that, you could not perform for, let us suppose, 1.5 years. Now they take a penal action against you, saying you have not started, I'm canceling it. Then you can rely upon saying that no, this is not a breach on my part, it's on the lessees, not a breach on my part in commencement of those swearing action. So you can take benefit of this clause under such circumstances.
Yes. Now, my lord,
So here, force major clause,
may I just
subject to correction by you, may not be available to you.
put this question to myself. Now, my lord, suppose, my lord, in this case, my lord, there is an ultimatum given to the party that you have to query, my lord, certain amount of sand or minerals. If you fail to perform, then also you have to pay for that royalty. As damages they can claim from. Now, my lord, why this delayed period is extended or added is exactly for this reason. Well, suppose, my lord, I have been given 5 years to query X quintal of minerals. For their action, my lord, I could not do for rioting or COVID pandemic. So they say, now, since this clause is there, I give you another 6 months for which you could not perform, which was not within your control, to perform that part instead of saying, please pay the damages. So exactly I'm saying, that if I could not perform for this 1 year for not giving me possession, this period is added instead
You have
of
suffered damages.
they will be suffering damages and they will charge on.
No. Here, according to you, for this delayed handing over of possession of 1 year, you have suffered damages.
No.
So what happened?
Not yet. Not yet.
You will be
Because my
suffering damages.
which is not.
Or you could not earn profit
No,
to the
I'm
extent you
giving a
anticipated.
situation why hypothetically why this period is to be added, why it is required to be inserted, why this was inserted. So, my lord, if that be the position, my lord, then, my lord, they add that time frame to my lease deed, asking me to
Under those conditions,
now, my lord,
under those force major clause,
yes,
it has to be a literal construction to the terms has to be given.
That's
cannot
why that-
impute something saying because on the part of the lessees, if the lessees perform and the government takes some action against for saying that it's a breach, then this clause shall come into operation.
No, my lord, that's why I say, my lord, force majeure, my lord, they say, my lord, if I fail to perform, which is not within my control, for force majeure, and they say, and other happening. Because this other happening
Other
has to
happenings
given
you may-
has to be given a liberal meaning. Anything which is beyond my control. So, my lord, if this anything which is apparently or admittedly is not within my control, why wouldn't I get that benefit of that added period, which is there itself in the clause? Instead of, my lord, going to the other, my lord, formalities under the Indian contract and calling from court, my lord, I've also thought for.
Why did you accept the possession certificate as on that date?
My lord, I had to be.
Why?
Because
Could have said no. Please correct this date of commencement from this. Why did you not challenge at that point of time?
no, my lord, even if, my lord, that's why I was taking, my lord, to the rule itself. My lord, can it takes the rule?
No, I'm asking you, the delay is the first part. Because you are now challenging an action which took place in 2022.
No, my lord, my
Cause of action, Mr. Chatterjee, the cause of action for this
It's
one.
not that I was sitting tight, my lord, from the date. My lord, thereafter, my lord, I started writing them representations. My lord, I went to the authority, a hearing was given to me.
When did you give the first representation?
First representation, my lord, as annexed in this petition. Then, my lord, kindly takes up.
What is the date?
My lord, just a minute. Kindly takes up page 112.
What is the date?
Dated 23rd of October 2024.
Yes.
This is my first representation.
Yes, in 2022, you are handed over possession.
Now,
The
So
representation
you
of
accepted that
122 will order.
without any reservation.
Huh?
Without making any reservation,
Order
you
of reference
accepted
which
that.
is August 12.
Without two letters, my lord, I would rely upon.
The date
You are
of
making a representation, does
এর
it
আগেও
give
আছে।
invitation, Mr. Chatterjee?
Now, my lord, here, my lord, I'm my lord, taking my lord, steps against the government authority. My lord, a position is clear, my lord, under law, my lord. If I am aggrieved by certain act before coming to a willing court, my lord, I must make myself clear before the authority. If the authorities, my lord, takes a decision which is now required to be challenged, my lord, then I have come forward this point. So, my lord, this period, my lord, up to their decision, my lord, I will be benefited of. My lord, with respect to the inordinate delay, repetition doesn't have a period of limitation, but definitely a question calls for inordinate delay. So, my lord, delay, my lord, in respect of, my lord, making of representation, my lord, it's not that stricter in the sense because I was making representation when my lease date is subsisting. It's not that, my lord, on the fag end, my lord, in 2026, my lord, I approached the authority before a month that you kindly extend the fee. My lord, I was making my submissions, making myself clear. My lord, in when 2 to 3 years.
Any other point, Mr. Chatterjee?
My lord, this is one. Second, sir. Kindly takes up. My lord, page 106.
106, yes. Second volume.
Second one.
Yes.
My lord, this is written by me.
Yes.
Without troubling with this small letter, kindly see the last line of the last paragraph. It is deemed that the effective lease period shall be commenced
No,
from
no,
the
no.
date of
Page
physical.
106.
106. This is of 2021.
Oh, it is deemed. No, no, you are placing from the middle. Yes, it is deemed that the effective lease period shall commence from the date of.
Physical possession of side block. When it
It's
was
your
made-
interpretation.
No, because I am making myself clear before that. That is on 25th of October 2021. Milord, 30th of August was Milord, the date of registration. So immediately on registration, after that, Milord, I have made myself, since I was given in possession or not given in possession yet, because my possession comes in 2022.
Yes. Yes.
Now, since nothing was done, only possession was given. Milord, then I started making representations. Kindly consider extend the period.
Yes.
And which culminated
So
into the
according to you, basically it should be 5 years from the date of possession.
5 years from the date of possession.
Yes. What do you say?
Two judgments have been passed by this honorable. Milord, annexed to the volumes itself.
Annex to the
Volumes itself.
nowadays the judgments which you are trying to rely upon
Those were relied
has to
upon.
be made a part of the writ petition, Mr. Chatterjee.
No, not at all. But since those were.
You have also adopted this practice.
I have otherwise copies.
That's a different thing altogether, but you have started annexing and making it bulky. Written notes of argument and this should be a part of the writ petition. Yes.
Now, Milord, this is filed by Honorable Simple Judge, where Milord, what issue was exactly this issue was raised. Milord, may I page the relevant portion. The fact, Milord, on the first page. The prayer of the petitioner in the writ petition is fruitful. The petitioner prays for direction upon the state authorities to consider the representation basis of for extension of period of lease on the ground of pandemic which intervened during existence of the lease. Secondly, the petitioner seeks extension of lease on the ground that he was handed over possession of the leasehold property months subsequent to the execution of the deed of lease. Then, my lord, this honorable court has allowed this, saying it should be reckoned from the date of physical possession.
So as laid down by the earlier judgment. So this judgment only follows the earlier judgment. Show me the earlier judgment.
But I could not give because this is unreported in server. When I tried to find out, I could not get hold of this.
There is no ratio decided here, Mr. Chatterjee. It's only the ratio that binds the court.
But this is old writ petition which probably is not in the server.
No, that's a different thing altogether. But it's only a ratio that binds.
Absolutely.
That's binding.
Absolutely.
No ratio has been decided here. Here it relies upon the decision of the earlier. Please show me the ratio.
Coordinate bench cannot bind. Feeder bench would definitely bind.
No. Coordinate bench also binding. Otherwise, it has to be referred. It's a binding precedent.
Yes.
So show me the what binds is only the ratio.
Ratio.
Show me the ratio decided here. It only follows. So ratio must have been decided in earlier decisions. Where is that?
Now, only thing, Milord, I can say, Milord, this decision, Milord, has a persuasive value before this court. Milord, if not binding. Milord, I am saying, Milord, a court has taken a stand. This honorable court by a coordinate bench. Now, Milord, I must be very candid also, Milord. This petition was travelled in division bench. Now, honorable division bench has upheld the principle, but factually has refused.
Upheld the
principle that it of the fact that it should be reckoned from the date of possession without touching that principle.
has said factually court has not looked.
Show me the ratio of this judgment.
But kindly takes up this decision. Kindly sees. The order is quoted in the second page. Thereafter, what happens, my lord? Mr. Banerjee, my lord, of the third page, my lord, Mr. Banerjee. The understanding council represents aggrieved by the fact that the learned judge directed the lease would be considered to be valid till such and such. He submitted the writ petition has been in possession of the land in question in 2000 since 2008. The renewal of the lease in 2016 was only a matter of paperwork. The writ petition was always and continuously in possession of the land. Hence, the direction of the learned judge extending the validity of the lease was uncalled for and will set aside the precedent. So, my lord, this way, my lord, this was accepted that since he was in possession, so the question of extension would not come. Otherwise, would have come.
The question, Mr. Chatterjee, this you cannot infer. What's binding is only the observations issue decided.
Because I'm
Mr. Chatterjee, not what it logically follows therefrom. You are trying to say from this it logically follows that.
Because why I say so, my lord, kindly tell us
That's
to
not
internal-
binding,
kindly-
Mr. Chatterjee. That's
My lord,
not
I
binding.
am the persuasive side. My lord, kindly tell us to internal page 4.
I'm on the binding effect.
No.
So this also only the ratio which has been decided is binding, not what can be logically deduced or inferred therefrom.
Because
So you are trying to logically that if that was not there, this
I
would have
know,
been
I
there.
know.
So
My lord, kindly tell us to internal core of the why I say so, it has a persuasive value also, my lord. My lord, this is the third line from top. My lord, this terminology, if that be so. So, my lord, on the
Mr. Chatterjee, we did not go that far. Please kindly come to page 3, top. This appeal has really become infructuous. So after this, all findings are omitted. After this, all findings are omitted. After infructuous, no further observations. What is your submission with regard to that?
My lord, if this appeal becomes infructuous, my lord, in my expression, then my lord,
Then the issue has not been decided.
by
The
a
issue,
division.
yes, by the division bench, that issue was not decided. All other observations, what can be logically decided, inferred therefrom, even if I accept that that's a ratio, it's an obit. Cannot be a
Yes.
ratio.
So therefore, my lord,
Because after this,
if
I've seen
therefore, my
this.
lord,
pass.
if rest is obiter, my lord, then my lord, I say, my lord,
Whether obiter is binding.
no, my lord, I'm not at all for the moment. My lord, I say, my lord, what the anxious
Please,
thought.
please argue on the law. Please show me, because none of the judgments lays down in ratio with regard to these points.
My lord, only thing, my lord, I would say, my lord, if my lord gives me time, my lord, I can bring decisions, my lord, on this, my lord, with extension of period of time. My lord, I should be very fair and candid, my lord. When this issue of extension of time is always considered, my lord, by courts, my lord, when question of time is the essence of contract comes in. My lord, whether I was at delay.
It's a commercial transaction, Mr. Chatterjee.
Yes.
File a suit. Make all arguments there.
Now, my lord,
Because as we have started by saying it's a commercial transaction, merely because one of the party is a state or an authority under Article 12, which is not maintainable. File a suit, claim for damages, everything you can get
my
there.
lord, I want on if the contract, if the terms, my lord, and they are within their domain with the terms.
Yes, why did not hand over possession within time?
Lordship, I am only maintaining the portal. Lordship, the lease deed says, as it was reported by the lessor, that it is from the date of registration. So I am maintaining.
Why you delayed in handing over possession?
Lordship, that the state.
My lord, I appear for the state authority, Lordship. My lord,
There was a delay in handing over possession.
My lord, may I submit? Man, this is the report of the ADM, Lordship. This is
the
the current
reason?
report, Lordship. Kindly see, Lordship.
Yes.
My lord has already gone through it, Lordship. The bullet, kindly come to the page 3 of the report.
Yes, page 3.
Yes.
There is no pagination here.
Yes, my lord, kindly excuse me for that. My lord, kindly from the forwarding letter, the third page.
From the forwarding.
Forwarding
back
letter
page.
from the third page, Lordship.
that the forward
Yes,
letter
Lordship.
as page one.
Page one, Lordship.
Right, all right.
Excuse me, kindly see. Yes, yes,
Main issue.
yes, Lordship, kindly see.
Yes.
The main issue raised by the petitioner is that a long-term mining lease deed was executed in its favor, and the same has been registered on 3rd August 21. But the possession of the leasehold land was provided to it on 22nd June 2022. Therefore, the petitioner prays for rectification of the field expiry LTML in the centralized portal as 21st June 27, calculating the lease period with effect from the date of delivery of possession. Thereafter, kindly see, Lordship, just now my lord has gone through it.
No. I will
Yes,
listen to
yes.
that. I'm asking you why there was delay in giving. Admittedly, there was delay in giving
Yes,
possession.
yes.
I'm asking you the reasons therefore. I'm not asking you the legal issues. I'm asking you why there was a delay in delivering possession. The report only quotes the rules from the reasoned order.
Lordship. Lordship.
But the report is
Yes.
to know about the factual part. That's
Lordship.
silent. Report is silent with regard to that.
Well, and second part
That's
of
only what is wanted. Other things,
yes,
you
Lordship.
did not file a report for what has been stated in the in the order under challenge. The only thing is that admittedly there was delay in handing over possession. What was the reason? Why you delayed in handing over possession?
Well, that
Can
specific.
you take advantage of your own
No,
wrong?
well, certainly not. But that specific instruction I have not got as yet, Lord.
That was the only thing that was
Well,
required. And the authority who has given this instruction,
well,
additional
district
district
magistrate.
he has only quoted his
No,
earlier order.
no, Lordship, kindly come to the next page of the report, Lordship.
Yes.
It is crystal clear as per prevalent statutory provisions, the commencement of mining lease period should be the date on which a duly.
That is,
yes.
that has been stated in the impugned order.
Yes.
For that, a report is not necessary.
Yes.
Report is only necessary why there was a delay.
Lordship, from the communication, it appears the position was with them, but demarcation was not there. If your Lordship kindly come to.
Can anybody start? Will
No.
you allow?
No, it's the position was there, but the thing
That's
is,
ineffective.
tender condition says that prior to submission of the bid, every aspiring bidders, they have to inspect the space. So prior to submission of bid, they have inspected the subject sun block. Thereafter, they submitted bid. The position was them. Only, Lordship, the demarcation part was there, which was not done. If your Lordship,
So unless demarcation is done, they cannot commence
that
with the
for the
quarry part.
purpose of demarcation, this was ultimately handed over on 22nd of
So
June.
that is the effective thing.
So the
Unless
reason for
without handing over possession,
yes,
without demarcation is nothing. So for that, you will take time. Let us assume in a given case 5 years of time. So lease will expire. What was the purpose for the lease? In a hypothetical case, let us assume you take 5 years of time for demarcation. And then on the last date, when it will expire, you hand over the possession certificate. And you will say, yes, gone.
Well, I shall take specific instruction. Otherwise, I can't say anything, Lordship. The reason for delay, what my Lord has categorically.
That's the only
yes.
issue. Other law points.
Yes, Lordship. That
has to be interpreted
yes,
by the court.
Yes, yes, certainly.
Ashok. No,
is
that's,
for
that factual, that report, that, please be prepared on the legal issues, submissions on the legal
I
issues.
only
Because
argue
I will
the
be-
preamble to hold and demise. Because this cannot be so disjunctive that registration without possession then 5 years.
What is the meaning of the expression demise?
Demise to devolve, if I can. And to hold, it is used with hold.
Demise, a demise is created by,
By instrument also.
so
So to hold.
you have got the answer now. So the balance will be in the
I know.
judgment.
That's why I was harping on to hold and demise.
That's why I'll be,
I have visualized the situation.
You know that, so you are trying to go.
because
around
I
the
will
bush
be
without
relying
the
upon a
bush.
judgment of the division bench regarding the damages part which your lordship has fallen from your lordship, passed by the division bench, that in case it's a commercial contract, if any of the parties they have any grievance, it is before the claiming damages.
Only thing kindly consider this 5 year adding, it could be rendering everything OTOs. Even in force majeure situation, they can say you can claim for compensation or damage.
Major, subject to correction by Mr. Chatterjee, cannot
If I
be
can
applied,
show that this
cannot be
not-
applied in this case.
If I can show
Cannot take the benefit of force majeure clause.
they are state for action of a state. If a situation of a strike called by state.
Let me see. Yes, yes, call the next matter.
My lord is keeping it on 27th, lordship.
27th.
Lordship.
On heading.
My lord, I'm appearing to the state in this matter.
Yes.
I'm sorry, I'm not personally present there.
Yes, no problem. Yes.
So the petitioner make a representation before the concerned department, can you come page number 14, madam? There are, in front of the Malta Medical College, madam, there are so many unauthorized construction has been, made, to which, madam, the free movement of the public is completely disturbed, madam. Kindly consider my representation.
Who is for the private respondent?
The private respondent, madam.
Have you served?
Madam.
Served? What is the endorsement?
Delivered, madam.
Delivered when?
First January 2026, madam.
1st January.
Sorry, 5th January 2026.
Delivered on 5th January. Yes, Mr. Basu, what is your instruction?
Yes, my lord, on the 7th of this month, 7th of January, this has been sent by the assistant engineer to the block land and land reforms officer to demarcate the
demarcation.
entire plot of land.
Where is that letter?
For
Do you have a copy?
demarcation and
Do you have a copy
no, my
of
lord,
that
he's
letter?
just sent it on the post, my lord. No, my lord, he just sent it, my lord. I gave him a rebuke and then he sent it, my lord. Online.
When?
So,
What is the date?
7th of January 2026. Yesterday.
Which BLLO?
This is my lord sent to the BL and LRO, English Bazaar, District
English
Malda.
Bazaar. BLLO is not a party. Please implement the
No,
BLLO as a
BLRO is
party.
not a party.
Please implement the BLLO English Bazaar as a party. Ashun. Petitioner claims to be the owner of.
কেটে দিলে আমি বলবো কি করে?
Local resident, madam.
Local resident meaning thereby social worker.
My lord, let your lordship know what has happened, my lord. He was also an encroacher.
He is an encroacher. Remove his encroachment also.
He was an encroacher. No, she was removed. That's why she's filed this as a public interest litigation.
Oh, he has been removed in by an order passed in a public interest litigation.
That's the reason she is taking a vendetta. Yes, that's why she's taking a vendetta out on all of them. Amar noy to Karun noy. That's the one thing.
The the order passed in the public interest litigation. The petitioner alleged Basu.
My lord, I have been discontinued to hear the order, my lord. I was put out.
No, when can you produce the order passed in the public interest litigation?
My lord, it'll take some time because unless I get the demarcation and the obstructions.
No, public interest litigation, you have said that the petitioner has been removed. Where is that order? Can you show me that order?
My lord, I haven't got the detailed report, my lord. I only got one page today. That also after a rebuke I've got it, my lord. It'll take some time. Maybe next week, any day, any day next week.
List this matter under enable Mr. Basu.
I have been put on mute, my lord. I cannot hear your lordship.
Liberty to deal as a party.
Yes, একদম উপরে করে দিন. On the prayer of the learned advocate for the petitioner, leave is granted.
My lord, I cannot hear your lordship's order because I've been put on mute and I'm out, my lord.
Call the next matter.
Number 26.
My lord, I couldn't hear the order, my lord, because I was put on mute.
I've kept
I was
it
put on mute,
on
my lord.
13th. I've kept it on 13th. I've given them liberty to add the PLRO as a party.
Great.
Yes.
Great.
Worship Miss Monica Roy is appearing through virtual mode.
Who is appearing?
Miss
My lord, I
Monica.
am appearing on behalf of the NHI, my lord.
Yes, yes.
The petitioner's land has been acquired by the NH.
Yesterday's matter.
No.
Yes.
My lord, I am dissatisfied with the award, my lord, by the competent authority.
3G5 arbitrator.
My lord, I have made an application before the authority to refer the matter to the arbitrator, my lord. That has not been done. That's why, my lord, this request.
You have made an application before
the
whom?
competent authority.
Competent authority. Who is appearing for the competent authority? You are appearing.
Yes.
Yes. Why are you not referring?
The provision says, my lord, and you see.
He has to approach the arbitrator. There is
Yes.
no question of reference.
Yes.
My lord, may I submit, my lord?
Yes.
3G5.
My lord, here, my learned friend, as per page 20 of Annexed P5, my lord, he is
Yes.
praying for an dispose of an application as per section 3G5. My
Yes.
lord, the statutory arbitrator is otherwise empowered, my lord, to dispose of this application.
Yes.
And my learned friend, my lord, is not made the statutory arbitrator as a party, my lord. Respondent
No,
number
he has
3.
not approached the statutory arbitrator even. He has sought for an order directing the competent authority to send it to refer
My
it to
lord,
the
my
arbitrator.
lord, my humble submissions, my lord, respondent number 3, means the district magistrate at Bakura is the competent authority here, my lord. Respondent number 3, that is the district
File an
magistrate.
application before the arbitrator.
He's the arbitrator.
My lord,
District
here, my lord,
magistrate, you have impleaded him.
My lord, I have made application before the authority itself, my lord. He is the
District magistrate, show me. You have to challenge before the district magistrate, sir.
He is the authority.
my lord, may I submit, my lord?
Who
My
is
lord,
the authority?
my lord, divisional commissioner, my lord, the divisional commissioner.
Competent authority is not the district magistrate, sir. Please see the provisions. 3G1, 2 is the competent authority under the land acquisition. He is not. Show me the initial award.
My lord, in this case, my lord, the district magistrate is the competent authority, my lord. Kindly see.
My lord, in this matter, my lord, at district Bakura, my lord, district magistrate is the competent authority.
And who
as
is
per
the
this case.
arbitrator?
My lord, the arbitrator is, my lord, arbitrator
The
is
divisional commissioner.
Medinipur, my lord.
Divisional commissioner. You have to
Divisional
approach the
commissioner
divisional.
Medinipur.
My lord, the notification issued by the National Highways Authority in case of this acquisition by the National Highways Authority, my lord, it is the duty bound of the competent authority to refer the dispute before the my lord.
Show me that.
My lord, kindly see. Clause 12, my lord. Kala means the competent authority and land acquisition officer is the duty bound. When I made an application before that authority, my lord. Statute never says.
PG5.
PG5 says
Be
otherwise.
determined by the arbitrator to be appointed.
Where does it say that they have to refer? Please show me. Come at 2 p.m. Please give a copy of this. Please give a copy of this notification to them. It does not subject to
My
correction.
lord, my humble submissions, my lord, the divisional commissioner Medinipur is the statutory arbitrator. If my learned friend
Approach
make a
directly.
fresh
There is no question
application,
of reference.
make a fresh
That is
application before the
Please come at 2 p.m. Please show me that's which that is the deposit in the court.
4 will.
All right, you come at 2 p.m. Give them this copy of the notification.
কমিশনের পোস্টিং হবে
They have my law to mention the matter of inclusion, court application or article 220.
Which group?
Group one.
New motion?
In this side, we call them court application on article 26.
No, that is a first time.
No, second time.
After affidavits.
Point of maintainability. Wait.
Yes. Call the list.
Upon notice.
Number 1. This matter.
And for the state, my lord.
Of the bank, my lord, at the very outset.
Appearing on behalf of the
Bank, State Bank, my lord.
I am the owner.
At the very outset, my lord, before my learned friend starts, my lord, I require some time to take instructions in this matter because allegation is primarily on me, as it appears, my lord, that they have deposited the money in the bank's account, their tenant, and the bank tenants.
They are tenant under you.
No, under them. It is a rent control matter.
What tenant under them?
No. It is a rent control matter. They have deposited the rent. The tenant deposited the rent in our account, in the account of the landlord, but the bank has not remitted the money to the rent controller.
Out of 131 challan, 20 challans has happened like this. On previous occasion, in the first round of petition, there was a direction to remit the entire amount 120 days, but except 20 challans, entire amount has been remitted, but these 20 challans has not been credited. So the rent controller has not remitted the amount. That is the issue.
How this is the group 1 matter?
The rent control matter will come under the group 1, rent, land matter. Under West
Rent control.
Under West Bengal Premises Tenancy Act.
You are the landlord.
Yes.
Who is the tenant?
Tenant is not the party. There is no grievances against the tenant. He has deposited the money on.
Tenant has deposited the money in the bank.
In the bank, but the bank has not credited in my account, in the rent controller account. Out of 131 challan, only 20 challans.
Rent controller account. I
think there is some system. The rent controller view, he can say.
I am for the state, my lord. I appear for the rent controller. My lord, the landlord had deposited the money to the bank. The tenant has deposited the money to the bank. The bank has not credited those challans, my lord, to the account maintained with the rent controller. The remaining challans were already credited.
Is there a procedure the bank deposited in the bank will credit? I don't think under the West Bengal Premises Tenancy Act.
That should not be, because the account is there.
Should not be done. That's not the procedure under the West Bengal Premises Tenancy Act. It's under the West Bengal Premises Tenancy Act. That's not the procedure.
Yes, absolutely. Once it is deposited, it always will be a government account.
Has to be, no. It has to be deposited. Any suit is pending? No.
No.
So it has to be deposited before the rent controller. Where is the question of depositing before the bank?
Those
There is
20
the system of
challans were not
depositing before the
deposited.
bank. Where is the system? Where is the provision? Taking West Bengal Premises Tenancy Act. Where is the system of depositing before the bank? Bank will credit.
Out of 131 challans.
Maybe, but where is
only
the
except 20 challans, all are credited.
where is the procedure, sir?
That's the procedure has to look in.
Then, if there is no procedure, please kindly come to section 21. That's the procedure under the West Bengal Premises Tenancy Act.
The account of the rent control.
Yes, there is no procedure for depositing before with the bank.
Kindly see the challans I have enclosed here.
No, I accept
It is
that.
not rent control challan. The bank has accepted it. There is no dispute about it. Nobody is disputing.
How can you? What is this procedure? You are for the bank.
I am for the bank, my lord.
I think, for my understanding, that actually money is accepting by banks, but on behalf of the government account. The rent controller has no mechanism to direct accepting the rent. Only by the bank through. That is the concept.
there may be a treasury account, the account of the rent controller. That may be, but the question of what is the inaction on the part of the bank?
As per the person of the rent controller, the amount has not been credited. That is so that the 20 challenge amount has been withheld by the rent controller out of 131.
It's the grievance of the rent controller. Rent controller should approach. What is your
Rent controller has approached. There was a previous direction of the coordinate group.
show me that?
That is page number 8. Start from page number 8. There is a previous direction.
All right, you take instructions because
But,
what
it is
is
such
the
a chaotic
procedure?
situation. Even in fact, my client are also not able to trace out the records. So that is
The records.
to ascertain as to where
Have you
where is
implicated the tenant?
No. There
Why?
is no dispute between the ten because they are
so that would be
deposition, that is
well,
the
that would help us because where he deposited actually what you
No, no,
That
challan
would be
is there.
helpful.
If you lordship,
Please implicate the tenant. That will help you
all right,
also.
all right.
I appreciate that there is no fault on the part of the tenant. May come and support your case also.
Okay, I will incorporate liberty will be granted.
And if some amount has been deposited with you and you are obliged to pay it to the rent controller's account, why have you not credited that?
that is the question that I also use with me, my lord. I'm also having the same question.
The procedure which you are saying is very difficult to.
But my lord kindly sees that it is not of any
Number
not any particular private account, my lord. It is the account of the rent controller.
You are saying the direction which you are now paying is directing the bank to credit the amount in the account of the petitioner maintained with the respondent number 2. If the account of the rent controller is with the state bank, why it will be where it will be again paid?
My lord kindly sees the annexures, my lord. These are the challans, my lord. Challans not paid into any private account. It is a challan or rent controller's challan.
So you are appealing for the rent controller. What is your instruction?
My instructions are, my lord, that with regard to the 20 challans, my lord, the remaining amount as per my
What is the procedure?
last direction.
Why it is being deposited before the bank? Please apprise me with regard to that.
Instruction I do not have, my lord. My lord, my instructions are, my lord, the rent controller's account was maintained with the state bank. The state bank would credit this amount to the rent controller, and the rent controller will thereafter
All right, then do one thing.
return the money.
Both of you file respective reports. I think that may clarify this.
Some time may be given for that, my lord. Some time because we have to
File a
ascertain.
report.
Yes.
I'm giving you time to file a report. The petitioner under the same heading. Yes, next.
The next matter.
এখানে কি স্টেট ব্যাংক আছে?
No,
না,
not really.
আচ্ছা, ঠিক আছে।
The next matter, amount remitted by the rent controller, I claimed interest on such amount. And that was turned down by the letter dated December 12. I am not entitled to get interest because there is no provision in the Westmoreland Limited tenancy Act. My point is this, my point, I covered the judgment of the Honorable Supreme Court on the point of equity. The petitioner is entitled to get interest from the date of deposit till to the date of remittance. That point was raised in another thing. There is no statutory provision. In the point of equity, para number I have mentioned 16, 17, 20, 21.
So this remittance, you have applied for the withdrawal of that amount.
Yes.
When did you apply for that withdrawal?
So on the previous writ petition, when I filed not accepting my application, I have filed the writ petition and as per order of the court, they have remitted the money. This time. I have filed the application.
When did you file the application?
After the order of the Honorable.
So previously you have not filed any application
Not
for
in the
withdrawal?
appropriate format. My lord would find that from the order.
No, please. So 21(9) provides that upon a deposit you have to apply then refund. So if you have delayed in making that application, why the interest will be paid? Equity has to be against you.
And my lord, the aspect of interest was also a part of the previous writ petition. My lord will find from page
So that's
7
a
of the
different
order.
thing altogether. Equity will be against you because if you have delayed, because notice was given to you with regard.
No notice was given. No notice was given.
Where have you stated that?
I was.
When you came to know about this deposit, please show me from the writ petition.
Yes.
When you came to know, when you deposited, when you filed this application. So merely because you have delayed in making an application, interest cannot be allowed for that.
The proposition in this judgment is this. I have understood. The proposition is this. They speak to the fact of claiming of amount. What happened in those cases? The ratio of the Supreme Court is the one person is enjoyed the money of the other. That is the ratio.
Here there is a provision. There was no provision for return of that. Please show me. That was registration stamp paper refund.
In that
matter. So there is no.
Other cases also discussed.
Yes. But in equity, if there is nothing, one cannot. But here there is a provision. Immediately you ought to have applied for this withdrawal. Unless you apply for withdrawal, how that amount will be remitted? Now let us suppose after 12 years you apply, yes, give me this. So you wanted this investment. As an investment, let it remain. After 12 years, you say, yes, give me a bank interest. Why? You could have withdrawn, invested in bank at that point of time.
I think there is a.
Please see 21(9).
There is a provision the rent controller has to serve notice to the landlord for withdrawing the amount.
Please see 21(9).
There is a provision for application.
Yes, application for withdrawal. So it's upon you to file an application for withdrawal. You may say equity, let us suppose that you have applied today
I-
and they are delaying for 5 years, yes. Interest,
I am reading out subsection 7.
yes.
On such deposit of the rent controller shall send in the prescribed manner the copy or copies of the application to the landlords or persons claiming to be entitled to the rent with an endorsement showing the date of deposit, such endorsement being authenticated by the seal of the office and the signature of the controller or some other officers authorized by him in this behalf. Such authenticated copy of the application shall be admissible in evidence in any court. That is, there is a precondition. Rent controller.
Showing that you have stated that this was not complied with, and when you came to know about this deposit, where from?
So that is a precondition. Rent controller.
Yes,
has to
yes.
be- rent
So you have to
controller has
make a positive allegation that this was not done, because otherwise, presumption will apply that all ordinary course of act was followed. It was duly done. That's the ordinary presumption. So unless you can show, state by in the writ petition, yes.
Your lordship's contention is this, that there is a lapses on the part of the rent controller, then I am only entitled to get interest. Otherwise, if I am responsible, I am not. That is the point. All right, so that that point has not been taken into account. That I am withdrawing the writ petition. I am taking considering one bit. Liberty will be granted.
My lord,
Otherwise, question of law can be decided.
my lord,
So
as
question of law has to be on facts.
At that point has not been taken into account.
Has to be on facts. And also because the tenant also has to be made a party. Because this deposit, acceptance of deposit, when an application is filed, then a notice has to be served. So then you have to be given an opportunity. If thereafter this deposit, then if you do not, after that service, you do not appear, and these deposits have been made since when?
Since I think 2014.
2014.
Never no notice was served by the rent controller.
Yes, so you sat tight from 2014 to 2025.
That's true. I approached, that was not been taken into consideration, then I filed a writ petition, then only they are taken into account for disbursing the amount.
Ashun, after some argument, the learned advocate appealing for the Yes, thank you.
My lord, may I audible, my lord? My lord, may I audible?
Application has to be made, but that has not been specified. be determined by the arbitrator.
Mr. Bhattacharya, it's usual. Who will determine application has to be filed before such authority unless the statute prescribes reference as in section 18.
Yes, arbitration.
Here, there is no question of reference. It's you, the person who is aggrieved,
To approach to the
has to approach the authority who is determining.
What is fallen from
This is
me?
elementary. You approach the authority, there is no question of reference. It's not a reference. It's not a reference. Reference can be before the court.
Reference after 3G. After 3G.
3G.
In case of 3H, will a reference to be made by the competent authority before the court.
Yes.
My
So
lord, the statutory arbitrator is otherwise empowered to dispose of this application, madam.
you approach the arbitrator.
There is no what is fallen from me, since there is no arbitration agreement between the parties, whether on my
Why
application.
it's a statutory arbitration. Statutory arbitration.
And leave on that below, I shall
Leave
accept
it
an
already
application
there.
for the divisional corporation.
I'm disposing of by giving
Yes,
liberty
yes.
to you to.
My lord, the statutory arbitrator, my lord, the divisional commissioner, Medinipur, my lord.
Divisional commission, have you impleted the? You have not impleted. Please implement.
No, my lord.
And I hear it now.
Or I can record. There is no necessity because he wants to prefer an.
My lord, the documents is with me, my lord, where it is mentioned, my lord, the divisional commissioner, Medinipur is the statutory arbitrator in the district Bakura. That is with my learned junior, my lord.
Divisional
My lord, divisional commissioner, Medinipur, my lord.
Only Medinipur.
Medinipur division. Divisional commissioner, Medinipur division is the statutory arbitrator in the district Bakura.
The
Divisional commission.
This is one notification that
Notification regarding what?
My lord, this is the notification, my lord. My lord, this is the notification, my lord, where it has been mentioned, my lord, the divisional commissioner is a,
You are appearing for whom?
National Highway, National Highway.
my lord, I am appearing, my lord, she is my.
Yes. Yes.
I am for the respond.
Yes. Yes.
They are asking review of your lordship's judgment.
Yes.
I do not find any tangible reason to. It is up to your lordship. They could not.
But for the opposite party.
Opposite party.
Where is the review applicant?
He is not. Other day also he did not appear.
None appears for the review applicant.
One and two. Lord, we are 1 and 2. 1 and 2. Respondent number 1 and 2.
1 and 2, yes.
I'm respondent number 3 to 5.
So this is with regard to the employee of Indian Association of Cultivation for Science. Part of the.
What is the wrong I have committed?
No, it's our failure that we could not produce before your lordship that the 6th CPC was actually approved. The ground on which the claim was partially rejected was that the 6th CPC was not approved.
Please
Therefore,
take me to that portion where
come to paragraph 33, that will immediately come back to your lordship's point.
paragraph
33 of your lordship's judgment.
it's difficult, Mr.
Begins at
Muzumdar,
page 21.
to recollect after
I just indicate your lordship.
after more than a year.
Right, indicate your lordship. Not
Paragraph 33.
of your lordship's judgment at page 21 of the application, or internal page 10 of the judgment. Pagination is down below.
Yes, yes.
It is
Not the case of the petitioner.
It is not the case of the petitioner.
Yes.
Herein that he is presently not in receipt of higher pay and allowance than that admissible to the corresponding categories of the central government employees. The OM dated September 30, 2008 also provides that the final package recommended by the group of officers will require the concurrence of the Ministry of Finance, of the Department of Personnel and Training as the case may be. Therefore, unless the final package recommended by the group of officers in respect of the 6th CPC pay scale has been approved by the Ministry of Finance, mere extension of benefit of 6th CPC pay scale.
So according to you, this approval is there.
I'm not. The recipient of the 6th CPC 6th pay commission recommendation, at the stage of 7th pay commission recommendation, the pay was sought to be retrospectively and adversely revised from 1996 with a cause for overdrawal which they themselves state their hand for. Now, not so the implementation of 7th pay commission got stalled, as well as the implementation of 6th CPC. So, not 6th CPC, although the autonomous institution had implemented, so not
decided to implement.
So the group of officers said, no, it is not in line with the central government employees, therefore it is not approved. Now, if your lordship will kindly, and in that context, paragraph 33 was pronounced. Now, please come to paragraph 37 and 39.
Yes.
As observed hereinafter, the group of officers was constituted for the autonomous organizations where the pattern of emolument structure is not similar to that of the central government employees. The said committee made certain recommendations to contain overpayments to the employees of IACS. The learned counsel for the petitioner could not satisfy this court that such recommendations were made on extraneous consideration. In view thereof, the recommendations do not call for any interference. Now 39. No document has been produced before this court to show that the final package recommended by the group of officers for extension of the benefits of 6th CPC pay scale to the employees of IACS has been approved by the Ministry of Finance.
So this is the ultimate thing where approval
is required.
Was done or not?
Now, please come to page 28 and 31. Not if your lordship is satisfied that this is the approval, then not
Page
28
of the review.
review application.
Page 28. Yes, page 28 is your right, is your query.
Query.
Yes, which column, which point?
The first point is, please come to query number 3. Whether DST allowed 6 CPC benefits to the AIs, that is autonomous institutions under it,
What is
including
DST?
the Director of Science and Department of Science and Technology,
Yes.
to the autonomous institutions under it, including ISCS. 2 to 6 is yes at page 31.
This was part of the writ petition.
No, that's not. We failed to produce a document. No, that's what not we are trying to do. But after not that judgment in Netaji Subhas Cricket Club or BCCI, your lordships have laid down the law. Their lordships in the Honorable Supreme Court have laid down the law. That even a mistake by an advocate constitutes a good ground for review.
You are very ground in ground in appeal.
It's a review. That was a review. That was a judgment dedicated for review. Supreme Court বললো।
Because that was the entire basis that it was not approved, and this right to information reply says it was approved. If that is approved, that has to be given. What is your submission on this? I think this is the only issue, Mr. And the entire judgment was only on the basis of, now it has to some extent come to my mind. Now, that was the only issue because
other parts your lordship has primarily decided in our favor. That's my understanding of the judgment.
What do you
believe there will be second thoughts on that?
We are the ACS.
They are ICS, you have nothing to say.
GST.
Yes, what is your submission?
Lordship, my friend is continuing this regarding the.
May I submit with kindly, my senior, my lord. If your lordship kindly come to your lordship's order, paragraph number 24, internal page number 7.
Yes.
If your lordship, it is evident. May I read, my lord? It is evident from the materials on record that the acting registrar, by a letter dated August 30, 2016, sought for necessary approval of the Ministry of Finance for the 6th CPC pay scale. The said letter records that on getting approval, incorporation of 6 CPC pay scale in the extent of bylaws will be made. The acting registrar issued a reminder letter dated January 17, 2007.
Those were not there. Then
My lord, yes, my lord, yes. Now,
no material has been produced before the court to show that necessary approval of the 6th pay scale has been obtained.
Now,
Mojumdar also accepts that there was nothing in the writ petition.
Yes. Now,
Accept that
yes.
fact. But now he has, what do you say to this?
Now, my lord, may I submit? Now, group of officers, they visited the institution, they have had the representative verify the document in the year 2019. At that point of time, they failed to produce any documents. Now, thereafter,
It has been approved.
No, if your lordship kindly see.
Some authorities have failed to produce.
If your lordship kindly come to page number 28, the query number 3 and 4, they have stated that approval has been granted.
Yes.
Now, if your lordship kindly see page number 31.
31. Yes.
These are of 2021. Post 2019, a group of officers, they visited the institution. If your lordship kindly see.
So, a group of officers visited when?
2019.
Thereafter, if the approval has been
But
given.
subject to correction, if your lordship, but when it has been approved, my lord, there is nothing, no date, nothing has been mentioned. When it has got the approval, there must be something. Yes, 6
Who has issued this this information?
Ministry of Science and Technology.
Science and Technology.
Representing.
Well, we are representing, but
so you state that which officer, where from did he give this information?
Then we have to take instruction, my lord.
Take instruction.
When it has been approved.
Yes, please produce this document.
When it has been.
Because Look, this is if the only ground was the final approval was not given. If the approval is not given, they are not entitled to. That's the decision.
Yes, my lord.
And now Mr. Mujumdar comes up with some document, uh, a reply to the
Query to
is
the
it
RTI.
after the judgment? No,
No, no, my lord. Prior to that.
for 2021.
One.
He comes up with a document which says you can verify this whether it was under this context.
For that,
what
my
it
lord.
was.
Yes, I just want to, my lord, take instruction when the approval has been. What is the exact date? Exact date when that approval has been granted, my lord. Then everything will be clear, my lord.
First boils down whether approval. If approval is
No,
given,
from the RTI,
that's relevant because
We'll relate back to that.
will relate back to that. Approval is related because the applications or the proposals were sent much prior to that. Approval has to relate to
But
that.
if your lordship kindly see 2016 letter of the register, what I have placed before your lordship, there is no whisper, my lord, that approval has been granted.
Sir is not disputing that. He is not attacking on merits.
Yes. On some new evidence, no new documents, now you want to.
That view is permissible.
No, no, I am not saying that. Order 47, it is permissible, my lord. I am not
There
saying
is
that.
a judgment, Mr. Majumdar, you are relying upon the Supreme Court judgment.
2005.
When can you come back?
Give us because it is a science of technology. For we have to from New Delhi, we have to take instruction. Sometime, my lord, I beseech your lordship. I leave it to your lordship. Sometime, my lord.
Already he has come up
After
2 years.
a long time, Mr. Majumdar, but it has been taken up.
No, we require 5 weeks time at least.
Only for this.
This clarification, how much time it
No,
takes?
just
We are
because
late to it.
the home ministry is not, burden, a huge burden upon the home ministry. So that's
Home ministry.
No, 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 no. Ministry of Science and Technology.
Science and technology, not home ministry.
We leave it to your lordship. Give us some time so that we can come back, my lord. Otherwise, if you fail, then your lordship pass the order.
Mr. Majumdar, learned Please bring that citation on the next.
467.
Yes. Yes. Civil division application. This is the yes, yes. His submission. The learned advocate appearing for the petitioner submits. Yes.
And at page 3, my lord, my lord has been pleased to observe that the last
Yes.
honorable division bench in WPRT 61 of 2022 held that tribunal committed no error in demanding the measure to the PICA controller for deciding the status of the performer respondent on the property as PICA as tenant by overlooking the decree of the competent civil court.
Please show me that judgment of the honorable division bench.
My lord, it is at page number 120 of the civil division and 257 of the
257.
257 of the review of the case.
Yes.
And we come to the page number 260, my lord. Division 260. Division.
Yes, 260.
Third paragraph, my lord. The honorable division bench held, we do not find any justification in observation of the tribunal in remanding the matter to the PICA. We do not find, my lord.
Yes.
One mistake has there is mistake, my lord has reported that division bench has not interfered. Rather, division bench has set aside the order of the tribunal, my lord. Kindly come to the last line of the order. Thus, we find the tribunal committed error. The tribunal committed error. My lord has reported tribunal committed no error.
Please kindly come to last sentence of page 260.
Yes.
We thus find that the tribunal committed
Error. Error.
in remanding the matter to the TICA controller for deciding the status.
The order includes set aside, order of the PICA is also set aside. In the under review, order under review, my stand has been changed, my lord. The totally reverse. My lord, stand has been reversed.
No, what was the issue here?
My lord, I have made an application for dismissal of the suit. The charter suit of 49 of 2009 filed by the police party, my lord. That application has been rejected, my lord.
No, the issue of maintainability of the suit was it before the honorable division bench? The issue of maintainability of the suit.
No, man. No, man.
Yes, then that is the ultimate conclusion. The issue of the maintainability of the present suit did not fall for consideration before the honorable division.
The last of what fault I have committed. I have arranged or judgment of the tribunal, but I could not place before the judge. That was what for. And come to the judgment passed by the honorable Islamic tribunal.
Please show me the order, impugned order, the order which was impugned before in the civil division. Please show me that.
The civil division.
Yes. Which was challenged in the civil division. Please show me that. Anywhere from the civil division or in the review, anywhere. Please show me what was under challenge in the
May 2025.
Please give me a minute. Yes, that was rejected.
After this execution of the issue by the tribunal and by the honorable division bench.
Yes,
My lord, what was the prayer of the suit, my lord?
yes.
And it comes to the page 65 of the civil division.
65.
My lord, I am showing from the civil
Yes,
division.
yes.
The
Yes.
plaintiff, type of the plaintiff said, a decree for declaration that the impugned decree, as mentioned in Schedule A, is fraudulent, illegal, or void one. In Schedule 1, that is not Schedule B, all the decrees are in connection with the title suit number 7 of 1991 by the third court junior division. So, in the suit of the opposite party has challenged the decree passing the title suit number 7 of 1991.
Yes.
My lord, what is the case, my lord? The case of the petitioner is that the predecessor of interest of the petitioner was the owner of the property.
Please give me a minute. Please give me a minute.
Regarding the
Please give me a minute. Yes.
The opposite party have challenged the validity of the correctness of the decree passing the title suit number 7 of 1991. Regarding the validity of the decree, judgment and decree passing title suit number, the division bench already have observed and passed the order. And come to the page number 180.
Yes.
The third paragraph, my lord, the fact emanates from the respective pleading leaves no ambiguity in our mind that the said party decree passing attestation number 7 of 1981 is still operating. And
Page
118 of the
civil division. Yes. Yes.
Paragraph number 3, I repeat, the fact emanates from the respective pleading leaves no ambiguity in our mind that the said party
The order passed by the division bench. Yes.
the said party decree passing title suit number 7 of 1991 is it is still operating and binding upon the party unless the same is set aside by passing a decree in the later suit. Subsequently, an approach now my lord next paragraph, it is beyond carrying of the doubt that after promulgation of the Calcutta Tenancy Acquisition and Regulation Act 1981, the power was not confirmed upon the Tika controller to declare the status of the person as Tika tenant, and therefore civil court jurisdiction in this regard was not taken away. The decree was passed in 1994, my lord. The power has been conferred upon the Tika tenant in 2005, my lord. After prolongation of the 2001 Act, my lord. So the decree passing the truth, the correctness of the decree has been tested by the division bench, my lord, and the division bench held that the decree and judgment passing the title suit is operating and is binding upon the party. So nothing remains in the suit, my lord. Even in the
That will be decided in the suit.
it already has been decided by the tribunal. Kindly come to page number. Come to page number 110.
No, please kindly come to page 120. We found that the tribunal committed error in remanding the matter
Yes, that's
to the Thika controller for deciding the status of the private respondent of the party.
come to the
Yes.
Pasari
Now
tribunal.
now the kindly come to the order of the tribunal.
I know.
Yes.
That I mistaken on the last one, I have not placed.
Yes.
So it is honest.
Page.
It start from 107. The relevant
Yes.
portion start from 110.
Yes.
The issue is before the tribunal matter. At the very outset of our discussion, it is pertinent to point out the entire dispute revolves around 2 points. Whether or not the land in question is a Thika land, or whether or not the applicant is a Thika tenant, my lord. Kindly come to the next page, my lord. The first paragraph. So from this order, we do not find any slightest tangible evidence which led to observe that Sheikh Akhtar Hussain, the opposite party here, is a Thika tenant. The tribunal held that there is no evidence to show that opposite party is a Thika tenant. As per section 5.3 of the Thika Tenancy Act, concerned controller is duty bound to give an opportunity of being heard to the person interested, but controller did not give any opportunity of being heard.
So this order has been set aside. Yes. So this order has been set aside, meaning thereby the order of the Thika controller stood revived.
The order passed in 2007. By the
This
Thika
see what
controller.
was challenged before the tribunal. Challenge before the tribunal was the legality of the order dated 18th of September 2007 passed by the Thika controller. So the tribunal remanded
Tribunal take aside earlier order passed by Thika controller
and remanded. That is what I am saying.
that from the remanding portion, I come to challenge that portion before the division bench.
Yes.
Division bench take aside the order of tribunal entirely and take aside the order of Thika controller too.
Yes. That is by the division bench.
That is by division bench.
Yes.
He no more Thika tenant. He is no local. Original Thika tenant.
That yes.
That's what we.
That will be decided in the suit. Take those points in the suit that it has been already decided in the by the Thika controller. Please place that. The maintainability will be decided.
That judgment of the tribunal and the division bench before the.
Sir, this was at the threshold. At the time of hearing of the suit, the issue of maintainability will be decided. You place all these materials. Where is the difficulty?
They are in position, madam. There is also an observation made by your lordship. When the
Place all points because this cannot be decided at the threshold.
page number 298 of
Yes,
the
yes.
review application, my lord.
Yes.
During when the matter was pending before the tribunal, my lord, they have illegally demolished my structure.
That's a different thing altogether.
And your lordship, sitting with the Honorable Justice Chakraborty, has passed an order that is at page number 300.
That's with regard to the construction.
They have no claim. They have no claim ability to.
All points are left open to be decided.
It is just bill. Basically, judicial order, everything has been decided in the tribunal, my lord,
Uh,
will be corrected, my lord.
yes, that I'm Yes. Next.
Lordship, 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 Lordship. Item number 465 is my item.
Yes. আচ্ছা disposed of করে দিন the review application stands. Yes.
Lordship, my item was 465. I was
Yes.
not, Lordship, I was not getting the connection actually. It is my
Other side
fault.
was there. What can be done? Bring your other side.
Lordship, then can your Lordship may please to fix it on next Thursday?
Please ask your other side because it was in his presence this order was passed. Please ask your other side to appear because order was passed in their presence.
Yes, Lordship. I'm not intending to hear out the matter today.
Ask them to appear. Please mention in their presence or ask your advocate on record to appear. Because
Yes,
order has
Lordship.
been passed in their presence. How can I
Yes,
resolve?
Lordship.
Ask them to appear.
Lordship, any order has passed today.
Yes.
The
dismissal is to. What is your item number? 465.
465, Lordship.
For default. In the, they appeared, they said you are not appearing, you did not also appear on the earlier occasion. Please ask them to appear.
Lordship can restore it, Lordship.
No. Order passed in their presence, how can I restore it?
Then,
Ask to be present, I will consider them.
then Lordship, I am filing another restoration over it. Grateful, Lordship.
Fine. Yes. Call the next matter. Yes. Yes.
Filed and can with the review application.
Yes.
For stay of the operation of the order.
Yes.
But the lower court has already passed an order of maintenance. So the
Can is all right. What is there in the main matter?
And in the main matter, Lordship, kindly come to ground number 2, 4, and 5.
Yes.
Page number 4 of the main review.
Ground number 2.
My personal Lordship, not appear on that day. And then my expecting to happen.
No, you appeared.
Yes, for an accommodation that was not granted because perhaps not applied to the court of the pendency of a.
Who was your junior?
SLP in the Supreme Court.
Who was your junior?
Do not apply to your Lordship of the fact that the SLP was pending and I was in the Supreme Court. That's why adjournment was not.
No, it was only directed that the section 24 application to be disposed of. This was, yes.
Section 24 application could be disposed of by
It's
the.
directed to dispose of the application under section 24 after giving an opportunity to the respective parties.
Yes.
How are you aggrieved?
No, that order has already been passed by the lower court.
Yes.
But the amount of maintenance that was granted by the order review in the review application, it was 25,000 on the basis of the admission of the husband. That is salary was 75,000. Now before ADJ Kollani, it has come to light that the salary of the husband is more than rupees 1 lakh. And my maintenance was reduced to 22,000.
I have not decided on the quantum. Look, that application, there was a transfer application pending.
Right.
During the pendency of the transfer application, this order was passed. I have recalled, I have directed the section 24 to be decided afresh.
No, your Lordship has disposed of this application on the point of jurisdiction.
Yes, and I have directed the section 24 to be disposed of.
The section 24 was already disposed by the earlier ADJ meeting.
That was recalled because when the transfer application was pending, that was disposed of.
On the transfer application, my lord, the transfer application was heard by Honorable Justice Shankar Sarkar, and then she had passed an order that
When that order was passed.
14th March 2024.
Yes.
And on 12th March 2024, already arguments were closed at the court in Bindapur.
The application was pending at a point of time when that order was passed. Thereafter, it was transferred. So the question is whether it was proper on the part of that court to pass. So I've only directed, I've recalled that order. It was.
I just want to ask one.
Yes.
Whether the question of jurisdiction
Yes.
comes before communication of the order of the High Court to the.
During the pendency of the application, the court should be slow in proceeding. 1987 supplementary Supreme Court cases.
Just for one.
That's the decision.
Kindly see of my CAN application, annexure.
Sir, there is a decision of the Honorable Supreme Court when an application under Section 24 is pending, court should be very slow in proceeding. So admittedly, when the order was passed under Section 24, this transfer application was pending.
So speaks for order on 2nd April and memo issued by the High Court was on 24th April. So what the lower court.
But the order was passed subsequently, but the application was pending.
I agree.
That's the decision. You have not seen the decision. I'm giving you the reference, 1987 supplementary Supreme Court cases. Please look at that decision. It's a half-page judgment. Starts from the left-hand side, ends 4-5 lines on the right-hand side. So short judgment, 2 to 3 paragraphs at best of that judgment that says during the pendency of an application, court should be very slow in proceeding. So because now it has been transferred, it has been disposed of. I've only directed Section 24. Now you have got your Section 24 now has been decided. Ashun, this yes, next.
Order number 469.
My lord, I am appearing for the.
Yes.
My lord, I am appearing for the reviewer in this application, my lord. My lord, if your lordship kindly comes to your lordship's order once.
Yes.
Internal page 5 of the order, my lord. Paragraph 18, my lord. It is well settled that a person in possession should not be dispossessed from an immovable property without due process of law.
Yes.
And my lord, 19, my lord, the learned trial judge considered the materials on record and was right in passing an order of injunction restraining the opposite party from dispossessing the petitioner till the disposal of the suit. My lord, the fact remains, my lord, that my lord, we are in the possession, my lord, not the my lord petitioner, my lord, in the revisional application, my lord. And my lord, in the present scenario, my lord, since the review was pending, my lord, the petitioner in the revisional application, my lord, has cut, my lord, 90% of crop, my lord.
That's a different thing. That's that cannot be a ground of review. For that, you have other remedies available.
No, my lord, that I am not harping it, my lord. But if your lordship kindly takes, my lord, paragraph 18 and 19 of the my lord of your lordship's order, my lord.
Yes. No. What was the order under challenge?
My lord, order was my lord, order misappeal order was my lord under a challenge, my lord. The petitioner challenged the misappeal order. My lord.
Please give me a minute.
My lord. Miscellaneous appeal being number 22 of 2024, my lord. The order was passed, my lord. Order dated is, my lord, June 18, 2025, my lord.
You are the owner of the plot.
My lord, I am the Rayat, my lord.
Yes. And there is a Borgadar also.
Bargadar, my lord, but my lord, he's my lord he was minor when it was recorded as Bargadar, my lord.
Yes.
I have challenged that, my lord.
So that has to be decided in a proceeding under
My
section.
lord, that is only the thing, my lord. I am, my lord, I am beseeching before your lordship if this matter could be, my lord, remanded back to the trial court, my lord. Because, my lord, the fact remains that we are in the possession, my lord. And paragraph 18 and 19 speaks, my lord, that it is well settled that a person in possession should not be dispossessed from an immovable property without due process of law. So, my lord, we are in the possession. How? I don't know, my lord, why the petitioners is claiming that they are in the possession, my lord.
Ashun. Yes. Yes. Restoration. Who is for the respondent? Have you served upon the respondent? Who is appearing? For the state. Delay of 827 days in filing the restoration application.
What was destroyed, Lord. Record was not found. Ultimately,
Where is the learned advocate for this?
I had served upon him. Your Lordship would find the order whether the record was reconstructed. For the hearing.
Can you ask your junior to call him because the mobile number is there? I'm passing it over. এটা দিয়ে দিন password. Yes. Call the next matter.
I'm appealing for the respond number 3. Good. There is a technical difficulty. On 2015, we cited illegal construction and enforcement of detailed justice of Sukuma Kashogari asked an order and directing the superintendent of interior to give a hearing. A hearing was held. It was decided against the defendant. Now, my lord, after that, no steps have been taken. We filed this, the present writ petition. That writ petition has been dismissed for default. And restoration application was filed with a delay of 46 days, but no limitation.
46 days.
46 days, but there is no section 5 application. Again, there was a.
You are opposing the prayer for restoration.
No, I am in favor of the.
You are saying 46 without any.
Without any section 5
But
application.
there is another problem is there. I am the respondent. Another restoration application is filed. And that application, yes.
Again, another restoration application without.
Why this restoration application was also dismissed for default?
That remains again one restoration application delay regarding 3 years and 355 days without any section 5.
And furthermore, what happened here?
Now the bill has changed. I am.
But if it was filed earlier,
No,
we can.
What is wrong there? Another wrong. But in the two application, in two paragraph, one in first one, there has been described that this is missed. Right. So the second one, another application, he says.
What is the main matter? What is the main matter?
Main matter was, well, I am not getting on the 10 years back matter. I have to serve the copy of the.
I have already served to the CAN application.
Because the initial application was of 2015,
Yes.
August 2015.
Yes.
2015.
CAN number 888.
If that is allowed, the 2019 application becomes infractious. আসুন, আসুন, আসুন। Belonging to your chamber. So who is for the respondent? Have you served? What is the main matter?
Cancellation of plot. They did not start passing any notice. Only a notice board was placed on the land. Yellow colored notice board saying that it has been resumed. The slot has been resumed. So no hearing, no notice.
What is the ground in the restoration application? Where is the restoration application?
The ground is before she got married.
The application is not here. কোথায় গেল application টা? One and two. Why? One is section 5. Where are the applications? ওটা?
And
Thereafter?
And thereafter, my lord, what happened, my lord, the client interested one person to look up the matter first, he was a senior citizen, suffering from various ailments. And my chamber also got shipped. So that was a communication gap. And when, and mainly the communication was pushed by advocate.
Who got married?
Who got married?
So marriage is the ground for restoration.
At the very outset, said, my lord, I do not have very good.
897 days.
There is some merit, my lord, maybe some merit in the men. Because total violation of national.
Who is appearing for this?
They have a time of dismissal for the ground of.
You sir, because it's a long delay. Is state.
State respondents are there.
Who is appearing for the state? Urban development matters. Who appears? Oh, Bidhannagar Municipal Corporation is also there. The petitioner is directed to serve a copy of this.
And 4:30.
Who is appearing?
Pankaj Haldar is
Where is
actually-
he?
I tried to contact him by phone, over phone. 5 times my junior called me. He's not picking up the phone. So if your lordship kindly takes up any other day, I'll give her a note.
All right, I'm making it none. The learned.
I was for whoever did not appear.
Opposite party.
No, I was the applicant.
Review applicant.
Wherever he dismissed.
Yes. Yes, yes.
The other matter they have tried of your lordship document. That is can number 1 is appeal. And the other matter is number 2, where we have asked that your lordship order to be modified, your lordship has granted certain payment, we want all the payment on all the heads.
Then this order is to be recalled. I think that's the best thing. Because both of you are aggrieved. Both of you are aggrieved.
We want to file affidavit, my lord. their vacating application.
Vacating application. So where is the applicant of the vacating application? Nobody is appearing.
Municipality, Bonga municipality and
Then contempt, in the contempt, the part payment made, again I have to make the new incumbent party going.
Now what do you want? No. That was directed. Why you want modification?
What your not, there were claims under three. The first step was withholding of money because the plant were not commissioned, because they were not being able.
That I have held that yes, for their fault it could not be.
So that part is covered. The other is, your lordship permitted them to file affidavit for idle maintenance, idle labor charges for maintenance, because we, unless the water and commission, and we are keeping on, have to file labor for maintenance, idle labor. And the other is refund of security deposit. Your lordship permitted them to file an affidavit. The affidavit, we have to file a reply. In the affidavit, they have stated that is also because the plant is not commissioned, they cannot. So indefinitely the plant will be not commissioned, will not get refund of security. And in one matter, Boshirat has allowed, I have got correspondences saying that they have asked them to refund the security.
That you have got.
The document, we want to file an affidavit incorporating everything, so that you are.
Affidavit against which can?
Can number one.
No, can 1 or 2?
Can one, can two is.
Can 2 is your application. Mr. Basu, Lanet Senior Advocate.
Don't take it up. I will not use issuers.
Then
Take up the vacating application.
Vacating, Mr. Basu, usually when some vacating application is filed, the other side, you come up and say this is to be heard along with the main matter. The vacating.
I am.
Usually you come and say.
Yes, absolutely correct.
So it's
saying why I am my lord, in this group of matters, I say group of matters, my lord has actually lordship mind and passed an order.
I appreciate that, but the main matter I cannot now take up. Vacating has to be while taking up vacating application, Mr. Basu, the main.
Indicate this your lordship, so that you can get your lordship.
No.
So indicate that one because of the fact you cannot take up the main matter, you lordship will not take up the vacating. Can make that observation. My lord has to. No escape. Your lordship will not take up my matter. So ground, yes, this ground. Let me try by luck. Because your lordship will not take much time in this matter. Because everything lordship mind.
It's not that, but Mr. Basu.
And his bigger mind. Only this observation will be.
Where is the who is appearing? Yes.
Yes.
You are appearing.
Hold on, I'm having the state respondent. Actually, unfortunately, I missed the list. That is, I couldn't bring the brief.
This is an vacating application by the state. No. This is an application filed by whom? Bonga municipality. Who is appearing for the Bonga municipality? Who is the learned advocate? Where is he? So best thing is that to dismiss this, then
ওদের দেয়া হয়ে গেছে
go out.
লাস্ট অর্ডারে ওদের ইয়ে দেওয়া হয়ে গেছে সবই দেওয়া হয়েছে এখানে তো নেবে না এখান থেকে নিতে পারবে না রিট পিটিশন মেন ইয়ে নেবে না হ্যাঁ এখানে কিছু করার
Then
Same fact, another day to be same.
if I dismiss this
তিনখানা
vacating
মিউনিসিপ্যালিটি
application,
একসাথে
then
করে দিয়েছে তো যার জন্য এটা
It is also taking shortcut. Don't do that. Your lordship will not take up this matter. This matter will be hard out of the better. Paragraph 27. Yes, yes.
paragraph
He has completed the entire project and that is intended to get the balance amount of the value of the work order along with supplementary bill for idle labor for future financial. He has not at all completed the said work.
And in the writ petition, your prayer was for release of the payment.
That's it.
Yes,
Yeah, affidavit filed by superintendent engineer, the work was completed. Contrary. 27 and 28.
the writ,
Your lordship judgment, another nowadays like all courts are determined. Taking your lordship's view in this matter, another it has been filed. Yesterday, I purposefully not come. You also release that matter. Taking as what is that we pass this on. Determination of my.
Yes.
Matter number 474.
Yes. This is an application.
Matter number 475.
Your Lordship, in this matter, Mr. Supratim Dhar is appearing before the state, Your Lordship, senior counsel.
What
He
is this application?
Your Lordship, he is unavailable to the court today, Your Lordship, praying for 1 week accommodation, Your
What
Lordship.
is this application?
My lord, my senior Mohammed Idris is on a is has to go to a doctor today, so I'm praying for not today.
Substitution application, sir. Why are you praying for not today? How long you are practicing?
Yes.
3 years. Please move these applications now. This is the best time. আসুন।
Number 476.
Yes.
These applications for restoration, the main application was dispersed on 15th May 2025 and it was filed within time.
Yes. What is the main matter? Who is appealing for the respondent?
The main application is, my lord, I have prayed for giving the.
Have you served this copy of the restoration application?
My lord, I have served, my lord, but my clerk is coming, my lord, I have given running. And for the restoration application. I did filed within time.
Pass over. Give the service. Pass over next. Yes.
Lordship, I appear on behalf of the opposite party, my lord. See you. I was the petitioner in the main revisional application, my lord. This has been taken out. This instant application has been taken out by the opposite parties, my lord, which I understand seeking modification of the order passed by your lordship.
For extending the time.
Yes, lordship. Lordship, I institute a suit, being ejectment suit before the small causes court. The suit was decreed in my favor. Thereafter, my lord, the instant applicant
By
preferred.
extending the time of disposal.
Yes, lordship. The appeal which has been preferred by this present applicant, my lord, is pending since 2014. Lordship, I filed the application under Article 227 for expeditious disposal, and my lord passed an order directing the learned 13th bench to dispose it off by September 2025, my lord.
Yes, where is the learned advocate?
They are not appearing, my lord. One application under.
What is the stage of that application? Order 41, Rule 27?
They are taking, my lord, adjournments. They have filed this application, my lord, on April 29, 2024. The application under order 41, Rule 27, my lord. That is pending, my lord.
This is an none appears for the
Item number 478.
yes. Yes. Who is appearing? None appears for the petitioner at the time of call. No accommodation has been sought for either. Accordingly, can 1 of 2025 stands dismissed for default. Next.
Item number 479. In item number 479, I get the apparent job of the.
Yes.
I evidence the service of can 1 lordship for restoration.
Have you served?
Yes, sir.
You served upon whom?
The state respondent lordship. The answer is respondent.
The learned advocate appeared. Have you served upon the learned advocate?
I have to take it. Yes, your lordship. I served upon him.
You have served upon Mr. Mahato.
I served upon Mr. Mahato.
Where is Mr. Mahato? You are appearing?
No, no, no.
Can you ask Mr. Mahato to come? Yes, what is the main matter? Yes. Ask Mr. Lohit Mohan Mahato or Ms. Ashima Sheel.
My lord, I don't have the telephone number of Mr. Mahato.
You don't have the telephone number of Mr. Mahato?
No, my lord.
Ashil?
No, my lord. তোমার আছে যাও তো একটু
Yes, yes. What is the main matter?
Kindly come to annexure G1 lordship will find the document related with the ownership of the trust lordship. Trust lordship is the trust is using for the transport of the sand lordship. Now the procedure is that lordship that the from the particular area point A to point B lordship to transfer a sand, there is generated challenge to be issued by the department lordship, and within that period of time the petitioner is able to transport the sand. Now, lordship, what happened that subsequently?
Where is the order of penalty?
No penalty has been shown, lordship, and subsequently when
You have said to quash the order of illegal penalty.
Yes, your lordship, they have not served any penalty to me, lordship. I made the representation, and I very candid to people, lordship, that during pendency of the writ application, they have withdrawn it, and now I am able to carry on my business.
Then
nothing
remains.
So
I'm disposing of by holding that it has become infractious.
Yes, yes. Because if they are not serving the document, lordship, that if any of the penalty has been imposed or not, but it's showing in the computer when the second challan should be issued on the very next day, lordship, then it's showing that the penalty comes before the DLLRO and settle the matter. Then after you'll be able to carry this.
Now it has been settled.
It has been settled, and subsequently penalty of the writ application, lordship, this has been.
Either Mr. Mahato or Ms. Ashil. Yes, next, call the next matter.
My lord, in the next matter, my lord, I am for the alleged contemner. That is the district inspector 480, my lord. 480 and 481 is the similar matter, my lord.
Yes.
My lord, regarding his area of salaries, my lord, everything, this contempt petition was filed in pursuant to the order passed in the year 2010, my lord. And my lord, ultimately we have sent it to on the part of the district inspector of schools, Punpo Medinipur, my lord.
Contempt application.
My lord, it is
Contempt application.
it is sent to the, my lord, Commissioner of School Education. Lord, not long back, my lord, in the month of October, my lord, on 31st October. ঠিক আছে.
This is exceptions to the report.
I have filed exception.
My lord, thereafter, my lord, we have sent it to the, my lord, after vetting his, my lord, claim, my lord, we have sent it to the, my lord, Commissioner of School Education, where it is pending, my lord. We have sent it, my lord, not my lord, it is sent on, my lord, They received, my lord, on 30th October 2025. 30th October. Kindly, my lord, fix it
2
next.
months time is not sufficient.
My lord, I have
2
to.
months time is not
No, no,
sufficient for that
sufficient.
authority.
No. It is obviously it is sufficient.
It will
My
be
lord,
done.
my lord, kindly allow me 1 or 2 weeks time. In the meantime, I shall submit the clear picture whether, my lord, any difficulties or everything.
Compliance report.
Sure, my lord.
Uh,
2 weeks time be granted in both the
learned
matters. In one matter, I am led by Mr. Bushu. He's and Mr.
yes,
Supriyo.
tomorrow he has come.
My lord, he is again, my lord, he has today, my lord, he has virtual mode, he is appearing. I don't know whether now he is appearing or not. But my lord,
He's not
but
appearing.
my lord, he has gone to the again to my lord Bangalore for rechecking.
Then don't give his name. He's
Lordship.
not here.
Lordship.
Don't give his name. Yes, next.
Enough.
Look, I have not what is the real point of the Lord? Tell you next month, I will tell you. I'm learning something in the meantime. Lord, his phone is not acting, Lord, working, Lord.
Who is for the contemner?
Contemner, Lord, just amount of contemner.
The learned advocate appeal.
Number 483, but I am for the petitioner, my lord.
Yes.
In this matter, my lord, I am appealing for the.
You are for the?
I am for the municipality, my lord, Mahistra municipality.
This is the first time, my lord, I am not
New
charged.
content. New content.
I have to serve the copy.
Violation of which order? 16th of August.
16.
But page 27.
So you have instructions to appear for the alleged condemner.
Lordship.
So please serve a copy upon him. What was the direction passed?
Madam, kindly have a look at the page, paragraph 28, madam. Your lordship's order.
For renew and this sanction plan. This is an application for. This is an application alleging willful and deliberate violation of the who is appearing?
In the writ petition, my lord, Mr. Mukherjee appeared for the petition. It is that matter, Eastern Paper Mills, my lord, for construction of swimming pool by the Vidhannagar Corporation, my lord. And your lordship was, my lord, pleased to, my lord, allow the writ petition. Now, my lord, the order passed by your lordship was, my lord, challenged before the honorable division bench. And, my lord, the honorable division bench was pleased, my lord, to set aside the order, my lord, passed by your lordship.
Yes.
So, my lord, since the, my lord, order passed by your lordship has, my lord, already been set aside, my lord. Now, my lord, I believe the content, my lord, does not, my lord, serve. Subject to correction, my lord. I do not know, my lord, whether they will turn up today or not.
Might be for that reason they are not appearing.
Perhaps.
The yes. Yes. None appears for the application.
Division bench, my lord. Code number 16, I was.
All right, no problem. There was a restoration application.
My lord.
You and Mr. Oshima Shil appeared in the main matter.
My lord.
So I have restored that,
My lord.
and the writ petition, the petitioner submitted, it has become infructuous. I am disposed of the writ petition as infructuous.
My lord.
Main writ petition. I have recorded your name.
My lord. Grateful to you, Lord.
Yes.
Not to sweet the
My lord, it is item number 484, my lord.
484. Yes. 484 is this matter. 484, you are appearing.
I am appearing for behalf of the petitioners, madam.
Yes.
Against Lordship's order, they have preferred an appeal.
Appeals, it has been set aside.
How does it set aside?
Nothing remains.
Ah.
Nothing remains in the contempt application. So I've disposed of the contempt application. Yes, next.
486.
Come to record. Yes. 486. Yes. None appears for the petitioner. Yes.
My application, madam.
487.
My lord, this is that matter. 98 years old lady. 98 years old lady has not getting her family pension till date.
Have you stopped?
Yes, my lord. Your lordship first initially, Mr. Tapon Mukherjee was engaged. Thereafter, Dipanjan Datta. Thereafter, Chondi Charan Deva was engaged. Your lordship has earlier occasion on 27th November. Your lordship direct me to serve the copy, entire copy on the.
Mr. Chondicharan De. Mr. De.
De.
Ask Mr. De to come. I'm passing it over. Pass over. Yes.
My lord, I have talked with him.
Yes.
He has
Left.
the court.
So I'm making it not today. Not today.
Short date, my lord.
Already, I'm making not today only. Yes.
Otherwise, my lord, you are to kindly issue the rule to the video, then video will come and everything will be solved, my lord.
Not today. Yes.
Next. On 8th August 2024.
You said Mr. De has left, so I'm making it not today. Yes. Next.
Yes,
My lord. I am a
petitioner.
kindly see the order passed on 27th of November, last order.
My lord.
Yes.
In paragraph
lord.
2, I understand the number which has been given, that is not correct.
My lord.
That is not correct. It might have some, they must move this.
My lord, I am most humbly submitting my lord.
Appeal has been disposed of 25th of July 2025.
My lord, most humbly I am submitting, my lord. Mr. Devopriya Chatterjee is appearing for the his advocate on record for the contemner, my lord.
Chatterjee is also appearing.
Yes, my lord. He is at present in another court, my lord. Devopriya Chatterjee is on record, my lord. He has to come up with something, my lord. Today he is not here, my lord, before the court.
Chatterjee.
My lord, he is in another court, my lord.
Pass over.
My lord, may I only praying for not today, my lord. Tomorrow.
Lilotpal Chatterjee to come. Ask him to come.
What steps they have taken?
Yes.
A wrong number has been given.
Pass over. Yes.
My lord, kindly allow us to come back tomorrow, my lord. This is my instruction, my lord.
Lilotpal Chatterjee to come. Call him. Yes.
Number 491.
My lord, 491, I'm told Mr. Senior Advocate Mr. Devashish Kundu is appearing for the petitioner.
Yes.
My lord, his clerk instructed for taking not today. My lord, he's not.
The contempt application have you served? I'm directing you to serve. This is an application for, this is an application.
My lord, 492, my lord, I appear for the petitioner.
Yes.
My lord, pursuant to my lord's direction on 27th of November, my lord, I have served upon the alleged contemners. My lord, this is affidavit of service.
What was the direction? This was with regard to the,
My lord, fast track Group D contractual employees of the fast track courts of Noida. My lord, we had sought for implementation of two government orders of 2008 and 2009. And my lord,
who is appearing?
my lord, Mr. Tonay Chakraborty was appearing in writ petition. But here, my lord, I am not aware, my lord, who are representing the contemners.
Where is Mr. Tonay Chakraborty? Has he come?
Well, I'm not sure. Possibly, my lord, he is not engaged.
He has not been engaged.
My lord, the Principal Secretary, Government of West Bengal, and my lord, the Additional Chief Secretary, Finance Department, my lord, was served, my lord. And your lordship.
I think the government pleader also appeared in this matter, or I requested the government pleader when the main writ petition was.
Yes, he appeared, but subsequently, my lord, on the final date, Mr. Tonay Chakraborty represented the state.
Can you serve a copy upon the government
My lord,
pleader?
page 17 is my lord's order, which records Mr. Anirban Ray's name.
Yes, please serve upon the learned government pleader.
Lordship.
The affidavit service filed in court. How soon can you serve?
My lord, I will serve by tomorrow. Because, my lord, these petitioners, lordship,
15th?
lordship, because,
15th
my lord, they are
contempt
only getting
application?
8,000 consolidated pay, my lord, since ages.
15th January 2026. Yes. Call the next matter.
Number 493. My lord, 493, I am for the applicant, my lord. This is first time contempt application, my lord. The lordship's order is at page 21. My lord, there is a direction upon the respondent to take immediate steps to release the remuneration and other allowances, my lord. That is at page 29, your lordship's operative part of.
So this is also bench clerk,
Yes,
same
my lord.
thing.
Bench clerk, same.
So this is for the first time.
Yes, my lord. This is for the first time.
Petitioner is directed to serve a copy of this application upon the alleged
For the content, my lord.
I appear for the petitioner, my lord. There was
Yes.
a direction by your lordship, my lord, to serve a copy of the contempt application upon Mr. Mihir Kundu, who had appeared in the writ application.
Yes, you are appearing.
I am for contempt, my lord.
You are for the contemner.
Yes, my lord.
Yes.
In compliance to the order of the Honorable Court, my lord, the recent hearing was taken up. And finally on 23rd 12 to 2025, and the advocate attended the hearing also along with his learned advocate.
Order has been passed.
In action is process, my lord.
What has happened? We were
When the order will, how long it will take to pass the order?
when the hearing was taken place, my lord, they had asked for
29th
further
December, my lord.
information. So they said that we need some time. We might require some further information since it's an old matter of 86-90, my lord. That is why. So I told them, I had advised them that since the matter is pending before your lordship, my lord, the matter might be taken up in the month of January. So
Yes. When do you want? How long it will take? Yes, I'm keeping it in the monthly list of February. The learned advocate appearing for the next. Yes, 495.
Lordship, Mr. Chandrachud Chatterjee is appearing on behalf of the petitioner, Your
Is
Lordship.
appearing?
Mr. Chandrachud Chatterjee.
Yes.
Upon instruction, I'm submitting, Your Lordship, the petitioners have received a copy of the minutes of the meeting, which says that the representation made by them is under a consideration. So, Your Lordship, I'm seeking for 2 weeks' time so that in case they to take a decision.
I would humbly pray that Lordship, I am appearing for on behalf of the alleged contempt one, Lordship. I was informed by my office that possibly in compliance of it, Lordship, they'll be convening a meeting next week, Lordship. So I would
keeping it in the
Lordship
monthly list
in
of
the monthly
February.
list of February, Lordship. That will be
You are for the alleged contempt number 1.
1 and 2.
So,
I'm for the port trust. My retired employees are concerned. So I am a party.
Contempt is not against you.
I do not know. We have been served, but then let me just.
No, contempt sir is not against you.
Are you?
We have been served.
No, are you the contemptor?
No.
Lordship, I am
Then
appearing.
why have you served upon the?
Lordship, the
Lordship, Shampoo Advocacy Court.
Alleged contemptor is Sri T.K. Ramachandran and Sri Ajay Seth.
Yes,
Lordship,
for the Union of India Ministry.
for implementation, Lordship, and I am
in the contempt application. Unless you are the alleged contemptor, you do not have any right.
I am appearing for the contempt number 1 and 2.
1 and 2.
Lordship.
The heard the.
तो बार-बार
Which item? Yes, Mr. Chatterjee.
I am instructed that on 17th December, the Honorable Supreme Court has been pleased to register the SLP.
Mr. Bera says the wrong number has been.
Wrong number has been given. You kindly check it.
What is the number?
According to my information, diary number 73310 of 2025, that is defective.
No, he has here it has been recorded SLP number 38146.
Wrong.
Well, diary number was, my lord, 73. My learned friend is correct, my lord. 73310 of 25. This was the diary number. This was the diary number. And, my lord, I have instructions which says 17th December, the SLP was registered. The SLP number, again, my lord, is not provided to me. But specifically, my lord, stated that 17, initially, my lord, what transpired initially defective, Lord, thereafter, Lord, 17 December 2025, the SLP was received.
Please put the diary number, because so this number is wrong.
Yes, my lord, SLP number, what my lord's order record is wrong, my lord. Apparently, my lord, there was a mistake on our part, possibly. Diary number, my lord, I am putting it, my lord, SLP number is not provided to me, my lord. Very
defective. Unless defect is cured,
no, 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 it says the 17th SLP has been registered. এটা তো 11ই ছিল এই নাম্বারটা।
So stop.
Item number 496. 496, I appear on behalf of the petitioner. Pursuant to the last direction, also a copy have been served upon the alleged contemners. So the alleged contemner number 2 and 3.
You are for the petitioner.
I am for the petitioner. So on last two, Howrah Municipal Corporation, no appeal has been preferred.
So you are the contemner.
I am the petitioner.
So you are saying that you are the Howrah Municipal Corporation?
Howrah Municipal, the commissioner and the other, they are the contemners.
Contemners.
Yes. Contemner number 1, he has now been discharged from his office, but the commissioner, municipal commissioner and the controller of finance, they have accepted the contempt petition pursuant to the last direction passed by your lordship. Lordship, the order passed
Have
by...
you served this copy of the contempt application?
Yes.
Where? Received?
Yes.
The evidence.
2 and 3 received, and 1 he has now been discharged from his office. New incumbent has come. Your lordship, kindly permit me to add the new incumbent. That is so far as the content number 1 is concerned, but 2, 3 they have received.
The learned advocate appealing for the
Your lordship direction, they were supposed to file another report. If your lordship kindly turn to your lordship's order dated 27th of November 2025.
Mr. Pan, no one is here.
So next day?
Not today or February?
No, not today. Because direct purchase, my lord, 4 months long lapse, nothing has been done till today.
আজকে not today করেই রাখুন, কারণ না চেস কল দ্য নেক্সট ম্যাটার।
হ্যাঁ,
yes. 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 Where is Mr. Somo Majumdar? Better to serve a call.
This matter, my lord, I am happy with the petitioner, my lord.
Petitioner, first time.
First time, my lord, but my lord, one thing, my lord, contempt number 1 is to be, my lord, Mr. Sumit Gupta has.
Yes.
The new incumbent has taken the charge.
New incumbent has joined.
Lordship, my lord.
In place of?
In place of Mr. Double Jain, my lord. Contempt number 1.
And this is the first time?
First time, my lord.
The learned advocate appearing for the petitioner submits that a new incumbent
Five hundred and 502. 501.
502.
No. 500 and 501
One.
are identical.
Sushmita Queen.
Sushmita. The compliance is in process.
Compliance is in process. I'm dismissing the contempt application. Nobody is here in the.
No. In the
At 502, I'm led by Mr. Siddhartha Banerjee in this matter. My lord, this matter requires to be released from lordship's list because the contempt is alleged against an order passed by the subordinate court. Your lordship had passed an order of injunction in the civil division, and the appeal was to be heard out by the learned first appellate court. The learned first appellate court extended the injunction order which was passed by my lord. It was extended from time to time, and by that time it was made final, and my appeal was allowed, lordship. We have alleged contempt of that order which has been extended by the learned first appellate court. So this ought to go before the honorable division bench because this is the subordinate courts.
The learned advocate appearing for the yes, what was the order?
Our order was, your lordship, at page 16. To conclude the proceeding, include the payment in terms of the memo. Direct purchase.
This is an application alleging willful and deliberate violation of the order dated
And 5, my lord, I am for the petitioner. This has been assigned to your lordship.
4 and 5.
Yes, 504 and 505. Next two matters.
504 and 505.
These are the assigned matters to your lordship, my lord. So,
Yes.
we are the worst sufferer in this because, my lord, in some portion, the matter, they said that they will release the land, but that has not been done. And
504 and
the
505.
other side is not there today, my lord.
Let me see the file assigned copy.
So may I pray, lordship, my lord, kindly fix up a date so that it may,
Today is the date it could have been reached. Mr. Pan, it could have been reached.
yes.
Yes. Let it remain. It's the first matter under that
Mallet.
because the other applications contempt review has been. So this is the effectively the first. Yes.
No, one matter has been not today.
Only one matter has been made
Yes.
not today, but all matters have been touched.
Yes.
Review, application,
Yes.
contempt, everything.
So first matter. I
So
will.
this is the assigned group first matter.
Mallet. Kindly do not disturb it. Next day. Thursday, next Thursday.
Yes, Mr. Mitra.
My lord, it was 509, my lord.
509.
It was heard by your lordship. It may come back to your lordship's mind, my lord. Vast property on, my lord, VIP road, my lord, about more than 40,000 square feet.
Mr. Mitra, how long it will take?
My lord, I will not take, my lord.
You have made your submissions,
Yes, I
but
have made, my lord, maybe, my lord, I shall, my lord, take it.
intervening vacations.
Give me 10 minutes and, my lord.
Who is appearing for the other side?
I'm appearing on behalf of the respondents.
Yes. How much time? Because Mr. Mitra has effectively concluded,
Lord.
and you are making
ready to
submissions.
start. Yes,
Maybe
Lord.
your senior or something.
Yes,
He was making submissions. How long he will take?
my lord, if we can start on the next date.
Of course, কতক্ষণ লাগবে?
How much time you will take? For that, I will have to adjust this.
Okay, 15-20 minutes.
15 to 20 minutes.
Yes,
Half an hour পেলেই হয়ে যাবে total.
Any day, my lord, at 3 p.m., my lord, if it is
All right. So it will be indicated 1 or 2 days in advance. Because, let me see, because many groups I have to adjust. So I will indicate that indication will be in the list when this group will be taken.
any day, my lord, if your lordship pleases to, my lord, give us I will tell your lordship the difficulty, my lord. A lawyer from, my lord, outside comes, my lord. Please, my lord, I can tell him, my lord, that this has been.
In this matter,
Yes, it's
assisting you. Even if there is 3:30, with that understanding, because 3 p.m. I can keep it, because if there is 3:30, half an hour,
Keep it at 3 p.m., my lord. I shall then, my lord.
because
Kindly keep it on any day, my lord. I'll be there. I am here.
no. I'm not saying
No.
it will not be in High Court, but
Kindly.
have you checked up?
I will manage.
20 তারিখ 20 তারিখ Item number
478, your lordship. Kindly,
478.
yes, your lordship, of monthly list, your lordship has dismissed.
What is this matter?
My lord, I'm not the council, but the council has asked me to like. My lord, if kindly, if your lordship restores the matter, it's an application, your lordship. But tomorrow, lordship, if your lordship.
78 টা equal.
26, my lord.
Yes.
A Passover, my lord. The restoration application.
78 টা recall.
Restoration application, my lord. The restoration was initially served, my lord. I missed the copy. If my lord kindly directs me to serve upon again.
What has been done?
A passed over matter, my lord.
Passed over.
My lord.
So you have to serve.
Again, my lord. If my lord kindly passes direction, I can.
76 টা the deal.
I was appearing for the private respond number 7, Bhushan Power.
Yes.
Petitioner has challenged an acquisition process which we have made submission that it has become infructuous. Your Lordship has heard Mr. Mukherjee on the last
Taken
occasion.
the next day.
Your Lordship kindly fixes it because this has really become infructuous. Acquisition process challenge, money taken.
It will be taken up on the very next day because up to 503 it has been done.
It has been.
504 is the first matter thereafter.
Great. Great.